Live for the petitioner, my lord. Lord, I am appearing for the.
I am appearing on behalf of the
by Mr. Chaudhary.
contender, my lord, in this matter.
Yes.
My copy of
Kindly
last
consider
copy of the
dated July, my
copy
lord.
of the last order has been sent by WhatsApp message. Otherwise, neither the copy of the contempt application nor the rule has been served upon my client. Now, what I am praying, my can adjourn the matter 2 weeks. My client will comply with the order.
Rule was issued to you. You have to be personally present in court.
Yes, yes, he is present, my lord.
Who is he? Yes, sir. What is the difficulty? I mean, why didn't you comply?
My lord, it was not. The factory is lying under PROCEEDINGS since 2016, my lord. It is lying under lock and key.
What was the nature of contempt?
My lord, Indian company proceedings by an order sum of ₹9 lakh was supposed to was directed to be given
The
by the
payment was-
contemptor.
was
My
out
part
of
payment
which-
was made. My lord, part payment was not made. My lord, that my lord find an company application before the company code. The when my lord was taking the company jurisdiction, my lord had given direction to make the payment within a specific period of time. But that has not
Who
been.
is this person?
My lord, he was a contributory of the company, my lord. But the company was not in existence as of date.
He was directed to pay.
Yes, my lord.
Yes. Why didn't you pay?
Would not pay. My lord, the factory is lying under closure. He will pay, my lord. Kindly consider.
What is close up?
Factory is lying under lock and key from 2016.
Whose factory?
Factory of the container company.
Factory of the company, that's a different proposition altogether. You cannot reopen the main order now in contempt. Why didn't you pay up? You had to pay. You paid only half.
He will pay, my lord. He will pay, my lord. Can he give us only 2 days time? He will pay, my lord.
Learned counsel, the contemner is personally present in court today. First up, learned counsel for the contemner submits on instruction that the contemner will pay the entire amount in terms of the parent order of this court, comma, thereby purging the contempt within 2 days. First up, next para. Accordingly, comma, as a last chance to the contemner to purge the contempt, comma, the contemner is permitted to pay the entire amount to the petitioner within August 12, 2025. First up, next para. The matter shall next be listed under the same heading at 10:30 on August 22, 2025, when the contemner shall again be personally present in court. Full stop.
A copy of the application may be supplied.
Please give copy of everything.
Otherwise, we cannot file the VOCA.
Yes, yes. Right. Do it immediately, please. I mean, immediately after going out of the court, just get a copy through your clerk, and please take his where he sits. And I know where he sits, but you take his address and give him a copy. Do it today so that he can do it.
Yes, my lord, I am giving it to you.
Thank you. Yes. Two pass over.
Number sir.
Two is that review application.
Sir.
3 is the.
Three is the one. Yes.
Well, I was on that loss of profit.
Stop. I'm on notes to you.
That loss of profit, that imponderables, how he overcame the imponderables, that is not mentioned. That lordship, for the loss of profit, I had cited the Unibro's judgment. It cannot be a mere guesswork, and especially such a large amount. It has to be evidenced, supported by evidence. And lordship may recall that is, I had relied upon paragraph 374 with maximum
374. Yes.
Yes, maximum stress on 374 to show that when he says these are imponderables,
Yes.
and there is no proof of even a sanctioned debt financing from ICICI Bank, or anything done, or any other source of funds. How? Because they would have brought in capital into this company, and with that business, they would have started something else.
All on surmise.
It's all on surmise. And also, I want to only now show one more thing in aid of this is the further impossibility in achieving this. If your lordship kindly comes to this same to the award to page. Can you give me 1 minute? Yes. Thank you. That's it. Paragraph uh, internal page 49. Yes. Paragraph 114 of the award.
114, yes.
This is on 26th October 23, the Claimants Council wrote to inquire about the status of the arbitration and inter alia brought to the tribunal's attention the order passed on 24th October by the US Bankruptcy Court. So this claimant went into bankruptcy on 24th October 23. So that's even more makes it impossible for the claimant to have earned profit by through this contract. And I want to show only one document. It's a public document. That is the claimant's bankruptcy petition that is filed. That's on just to show they are not cited that non-performance of this contract has led to bankruptcy. The reason for bankruptcy is that they suffered some award from a third party against the claimant, which has led to their bankruptcy. And they filed an application for self-declaration of bankruptcy. This is a public document. If your lordship allows me, kindly.
Mr. Mitchell, better not to.
Better not.
Better not, because they can take an objection.
Very much.
So, but it's not even alleged that it was due to this.
Not due to this.
It was
They had
independent.
gone. They had become bankrupt within 1 year because the so-called cause of action for the damages is supposed to be 26 September 2022, and they would have earned the profit over several years through this business. And within 1 year, say 24th October 2023, this claimant goes into bankruptcy. And in fact, my suit, anti-arbitration injunction suit, which we had filed in the commercial court at Rajarhat, was temporarily stayed by them on the ground of their bankruptcy. I have got the judgment, which this I can rely upon, because they lost in the court below. Then they came up in appeal, in revision, and they got an.
Whatever you hand up, Mr. Mitchell, give a copy to
This
them.
is
so
the
that they-
judgment, yeah. Yes, well, this I am giving. This is the judgment which ultimately they lost, but on the first day, they got an ex parte stay of the arbitration suit. So by the time we were able to get this order vacated and the matter dismissed, the award was published. So they achieved their purpose, but ultimately lost. I should kindly seize. Paragraph 2 refers to my title suit number 17 is an anti-arbitration suit. During the pendency of the suit, the petitioner defendant number 1 filed an application under section 151 of the Code of Civil Procedure. With a prayer,
So, but stay was not granted.
stay was not granted by the court below.
And revisional application also.
Divisional application first they got an ex parte stay. Or they got an interim stay.
This is the dismissal order.
Final order of dismissal. They got an interim stay, which was. I'm giving a lot.
But this is not that stay order.
So this is the final order dismissing it and vacating the stay. But by that time, the award is already published.
All right.
The 31st January.
31st January 2024, they got an interim stay. 31st January 2024, they got an interim stay of the suit when it was at the final hearing stage. I mean, the injunction application was at the final hearing stage. And then ultimately the matter was reserved for judgment, and judgment delivered on 22nd May. Before that, the award was made, basing on this bankruptcy. That is, I'm very grateful. That's all.
Anyone else from this side? Completed. Now the reply.
Lordship will come back with the reply. We'll start the reply on the next Friday, my lords. We'll have a lot of things to compile and start with.
There's
the
nobody
reply.
else behind you, so we'll have to rise them.
Lordship, because although it's been by different seniors, we'll have to compile and give a comprehensive reply. Senior Lordship, we will give a.
You should have started with the previous ones, the ones who have already argued.
Lordship, we
Because
were under
this
the.
is going on for quite some time. This is section 48.
So, Lordship, I understand. We are the award holders. I understand. We are the ones who
But
are
they
supposed
want
to prosecute.
to
I
stop.
understand, my lords.
Yes.
In the meanwhile, there have been
And
certain
we are also
developments.
the Indian judicial system also suffers.
No, absolutely, my
So
lords.
late on.
I know that's falling for my lordship, and rightfully
Mr.
so.
Thakkar expressed an apprehension that there is a notion apparently that these foreign awards should be implemented. No, we don't have any such notion. May not be implemented if section 48 is
Lordship,
satisfied, won't be implemented.
Absolutely.
But we have to decide the matter early.
Absolutely.
And this
my
is
lords.
going on for months.
I understand, my lords, but the only thing is that there has been certain changes there. We don't know at least who will
Don't make it a
also come up and
typical
who will also come up and address my lords.
typical appellate matter. I mean,
No, lordship, it's not that.
It's
The
an
company has
arbitration.
gone into liquidation in US. The company has. So we also have to understand who's going to come up and address my lords in the reply. Lordship, I would not take that entirety.
Next
on
Friday is a
myself
holiday,
as of now.
15th. So very well next.
Which will not take me amiss. I just
So
that
I take
that
you
the instructions, my lord, because we don't know who's actually going to address my lord at this stage.
The arguments of the respondents are concluded. First of next para for rejoinder arguments by the petitioner, comma, on the prayer of the petitioner, comma, the matter is adjourned and shall next be listed on August 22, 2025.
So grateful, my
Yes.
lord.
Please just have your arguments, notes of argument drafted in the meantime in
My
nutshell,
lord,
so that
my lord, as the arguments are happening, my lord, I'm keeping a
whenever
draft-
it's over,
draft ready. My lord.
it will go on definitely till the puja vacation. But before that, so
My
that
lord,
we
I'm-
have some food for thought in the. during the
I'm
vacation.
keeping it ready, my lord. Grateful.
Grateful, man.
Four.
Lordship,
Four is that metro that.
Lordship, I apologize for the inconvenience. In this matter, Mr. Jishnu Chaudhary, learned senior counsel, is appearing. He's not in court today.
Not in court today.
Lordship. Praying for an adjournment.
On the prayer of the. This is section 37 or 34, I forgot.
34.
34. On the prayer of the petitioner, let the matter stand adjourned and be listed next on August 22, 2025.
Gratefully, Lordship.
Fourth to 8 দেখাতে হতো তো।
So I appeared for the respondent in 5 to 8 minutes.
Respondent.
Yes, minutes.
You were arguing. The respondents
No,
were arguing.
that's the learned senior counsel, Mr. Tilak Bose, were arguing for the petitioner.
The
They
Tilak
want to
Bose was
conclude
arguing.
today.
Should we pass over or what?
Let's pass.
Passing it over for the time being. Let us see whether
Yes, ma'am.
pass over.
Obliged.
Order.
My lord, I appear for the respondent. You know, the petitioner was to continue making submission.
Who was appearing for them?
My lord, if my lord may grant
Anyway,
me a
just
second.
we'll pass it over for the time being.
My lord,
Pass over.
grateful.
My lord, I am appearing on behalf of the respondent number 2. I am led by the senior counsel, Mr. Jaydeep Kaur. He is online appearing.
You were arguing the matter. The respondents were arguing.
No,
or
but-
they were to start. They were continuing.
My lord, the matter was kept parted.
Parted, I mean, in the middle of their argument, or you had started?
No, we have not yet started.
You have not yet started.
I'm just filing the written opposition affidavit in opposition, Lord, today.
Correct. The affidavit in opposition filed by the
Respondent
respondent
number
number
2.
2 today be kept on record, full stop. However, none appears for the petitioner at the time of call,
And there are other respondents also.
as well as the other respondents, full stop. Accordingly, let the matter stand adjourned till August 22, 2025. Full stop. The time for filing reply is extended till the said date.
My lord, deeply obliged.
অর্ডারটা রেকর্ড হয়েছে তো? বুঝতে পেরেছো তো? আমাকে অনেক সময় মুশকিল হয়ে যায়। না হলে বলে দেবে, আমি আবার রিপিট করে দেবো।
Your Lordship, in item 12, I appear for the petition laid by Mr. Joyantamita, senior advocate and current.
You are passing it over for the time? Yes. Pass over.
My lords, in 13, I appear on behalf of the petitioners.
You have passed it over. Let us see whether they can come.
My lords,
Will-
13. Next matter. Okay.
Oh, acha. 13. Pass over.
13, my lords, I am appearing on behalf of the petitioners.
We're just passing over, not recording any order at now, at the present. So,
Okay, very well, my lords.
15, এটা? No, 14. 14. Pass over. Pass over. Same. Pass over. Pass over. Same. Pass over গুলো রাখো।
আমার appearance.
5 দেখি একবার ফাইলটা। আমার আগের নোটটা একটা যে কোনো আমার নোটসের ফাইলটা দাও। They were arguing.
Yes, my lords.
ওই তো এইগুলো বোধ হয় এখানে হাজার হয়ে গেছে। You are for which respondent?
Plus, there's only one respondent.
One respondent. On the first call, the matter was passed over, full stop. Even on the second call, none appears to move the matter on behalf of the petitioner. Full stop. Next para. Petitioner, although learned counsel for the respondent is present in court. Full stop. Next para. Let the matter stand adjourned till August 22, 2025. We have recorded your presence, but give your name only.
Obliged, my lords.
5 to 8 combine একটা order. Correct. এটা নিয়ে না ফাইলটা দাও 9 10। আচ্ছা দুপক্ষেরই কেউ নেই, একটা অর্ডার রেকর্ড করো। If the matter was passed over on the first call, full stop. Even on the second call, none appears for either of the parties. Full stop.
Your Lordship,
Yes.
Your Lordship, I appear on behalf of the petitioner, Your Lordship.
মানে এই অর্ডারটা হবে না, অন্য কিছু অর্ডার হবে, রেখে দাও। Yes, move the matter.
Your Lordship, I'm being led by Mr. Pradeep Chindra, Your Lordship. He's
Yes.
having some difficulty in joining virtually, Your Lordship. He's appearing from Delhi, Your Lordship.
What difficulty?
I just tried to contact him twice. He's saying that he's having some issues on his end, Your Lordship.
My lord, may kindly take the last order. My lord, dated 16th May 2025.
No further adjournment, you're Mr. Ghosh.
No, Your Lordship. I am Mr. Ghosh's junior, Your Lordship.
What is
I'm
your name?
Mr.
The juniors also
Abhishek
have
Roy
names.
Chaudhary.
Mr. Roy Chaudhary, you have to start the matter. Otherwise, because the last order says long adjournment was sought, refused to move your case. The matter was postponed till June 13.
Your Lordship, may Your Lordship grant me a short passover? Your
No,
Lordship?
this is
I
the
know
second
once it has
call.
been passed.
No, Mr. Roy Chaudhary, this is the second call. You missed on the first call. So you have to start it. Or we close arguments on your behalf and we will hear the respondent.
Your Lordship, I humbly pray for one passover, Your Lordship. I understand that it has been passed over once, Your Lordship. But I humbly pray for a
No,
passover.
you should have been prepared in the matter. So or we'll impose costs. And that would be prohibitive. Otherwise, you won't be coming.
Your Lordship,
It's
one
not the
opportunity-
duty of the court to invite people. If
I
you don't come, the
totally-
argument gets closed. Very well, we are passing it over for a second time.
Oh, bless you, Lordship.
এখন অর্ডার রেকর্ড করুন, আবার পাস ওভার। এটা থার্ড কলে। Please keep somebody on the third call.
My lord, I'll be here.
Item 12. দেখি ফাইলটা আগের অর্ডারটা দেখিয়ে দিও লাস্ট চান্স হলে আমি পাঠাট ক্যান্সেল করে দেবো
Your Lordship, in item number 12, I appear for the petition laid by Mr. Joyanta Mitra, senior advocate, and
on the last 2 occasions none had appeared for the parties. Now, on the last 3 occasions, so no further adjournment. This is the second call, so either you begin or we I'll cancel the partner and put it somewhere else.
Your Lordship.
No.
I'm in
No,
difficulty,
no,
Your
this is the
Lordship.
second call. Sorry, no. You have to start the matter. You cannot come before a high court on at least without a brief, or any court for that matter. Why high court?
Your
Even a
Lordship,
district court.
Your Lordship, I'm
You
carrying
cannot
soft
come before a
copy.
high court and pray for adjournment without a brief. You have to have something.
Yeah, sure. I'm calling a soft copies of.
Soft, you try, then start with the soft copies. Where is the device?
Yeah, Your Lordship.
I can't see the device even. Yes, put
Your
it
Lordship.
on a visible spot
Your
so that I am
Lordship,
convinced that you have soft copies. Open that and start the argument, please.
Your Lordship.
No,
I'm in
no further
difficulty.
adjournment. No,
Your One
I
last
can
opportunity.
cancel the part. No difficulty on my part. It will be easier for me. এগুলো কি অ্যাসাইন ম্যাটার
Yeah,
পাঠার ম্যাটার বলে ক্যারি করছি
Your Lordship, may he passes over. I'll try to. Your Lordship.
no further adjournment. Either you start it or I'll just cancel the part. It's not a threat. I don't get fun out of. I'm not a sadist. But courts have to have some business to do. We are getting paid for that. I mean, so we are not having a picnic here. So we have to have some matters. I mean,
Your
if
Lordship,
counsel don't
does-
choose not to argue on the second call also, and
Your
on the
Lordship,
last 3 occasions, in fact, none appeared for either of the parties, or
Your
either
Lordship,
none
to the-
appeared or it was adjourned on the basis of somebody's prayer.
Your Lordship, the council is on legs. Your Lordship, as I've been informed, Your Lordship.
They will
As I-
always be on legs, but the juniors have to start the matter, sir. What is your name, Mr. Singh?
Yes, Your Lordship.
Mr. Singh, you are there on the last occasion, so you know the matter. Please start.
Your Lordship.
At order, record.
Your Lordship, Your Lordship, kindly pass it over.
Even
Lordship,
on the first call, comma, the matter had been passed over. Full stop. Even on the second call, comma, learned counsel appearing for the petitioners seeks an adjournment. Full stop. Despite repeated requests by the court, comma,
Lordship.
Mr. Singh, learned advocate appearing for the petitioners, refuses to commence arguments. Full
Lordship,
stop.
may-
From the
may-
order sheet, comma, I find that on November 29, 2024, comma,
Your Lordship,
none
this is,
of the parties had appeared when the matter was called on for hearing. Full stop. The same exercise was repeated on January 17, 2025, comma,
Your
when
Lordship,
on which case also none appeared for either of the parties. Full stop. Next para. On May 16, 2025, comma, learned counsel for the parties had prayed for an adjournment. Full stop. Since it is evident that the parties are not interested in continuing with arguments, comma, the marking of the matter as a part-heard matter is cancelled. Full stop.
Your
Let the matter go out of the list with liberty to the parties to mention before the regular bench having determination.
Your Lordship, in the
Next matter, please.
Your Lordship, the last occasion, senior Joyanta Mitra had prayed for an adjournment as he wanted to
With
argue
liberty
the
to the
matter.
parties to mention before the appropriate court having determination, bench having determination. Next.
My lords, in 13, I appear on behalf of the petitioners, my lord.
This is 13.
Yes, my lord.
This
I
is
appear,
13.
on behalf of the- I appear on behalf of the petitioners, my lord.
13 you are for the petitioner.
Yes, my lord.
Right. Yes. দাও ফাইলটা দাও ফাইলটা সবকটা ফাইল রেডি রাখো আমি সব নেবো অর্ডার পাস করবো কোনো না কোনো অর্ডার দেবো লাস্ট চান্স ফর রেসপন্ডেন্টস
Yes,
petitioners had concluded.
Ready.
Yes.
Yes, my lord.
Yes. You are for the
I appear for the respondent.
you are competent enough to start. I won't leave you. Start.
The list has collapsed. My brief is coming.
Second call. No, sorry. Take my
But I'll just indicate the brief facts, my lord.
take your breath. I'll give you 2 minutes breathing space.
No.
Literally
start.
breathing space.
I'll start.
No, take your breath. No difficulty. You need not breathe loudly into the microphone. I understand that you are out of breath. Take your seat. Take your breath.
No,
I'll go through the papers. Just let me just remind myself of the matter, and you take your rest, and then
It was that matter, my lord, where proceedings had been initiated by the Calcutta Stock Exchange
yes.
against the company, my lord.
You are the stock exchange.
I am the stock exchange.
Yes.
My lord, Mr. Mukherjee was appearing for the petitioner. and I was led by Mr. Rai, my lord. We have also made submissions.
Mr.
extensively.
Mukherjee,
Mr.
Mr. S.N. Mukherjee.
Mr. S.N. Mukherjee, my lord.
Last occasion, his name was not recorded. ও ওটা আগের না, এইটাতে আছে, কোনটাতে আসেননি এসেন মুখার্জি। Shaunak Mitra appeared for the petitioners. Pratik Shanu on the on the previous occasion, none appeared before that. Shaunak
Difficulty, my lord, was on both the occasions. I was online, but in the car, so I did not make any formal
Shaunak
submissions.
Mitra before that. Pratik Shanu before that.
Yes.
Pratik Shanu
Both
before
of those
that.
occasions, my lord.
Mr. Mukherjee never made, literally he never appeared.
My lord,
My lord,
prior that, when
you
your
check
lordship was
in the December 2023 order, my lords, that's when he appeared and he
your lordship
made
at that given
submissions.
point of time was taking up the matters in courtroom number 9.
So they have finished. It's your
They have
turn.
finished. They have finished, and it's appearing after.
You remind me first what they argued. Yes.
The issue was, my lord, there was a proceeding initiated in the year 2004. Now, the writ petition had been filed in the year 2023. No, 2022, but that
22.
2022, my lord, wherein they had sought for refund of, my lord, the base minimum capital which was required to be maintained by the company with the stock exchange, since the company was a broker dealing in the stocks which were listed in the company with the stock exchange. Now, during this period, there have been issues regarding that particular proceeding, but that had not culminated into a final order. Now, after this writ petition was filed, my lord, there was an order whereby the stock exchange was directed to dispose of the matter within a period of 45 days. Now, pending that, during the interregnum of those 45 days, my lord, the petitioners before your lordships had preferred an appeal challenging that particular order, whereby the Honorable Division Bench, my lord, was pleased to hold that the matter be remanded back and the matter be heard in totality afresh. Now, the liberty was also granted to the petitioners to place the order which could have been passed by the stock exchange during the interregnum before the learned single judge. And accordingly, during the interregnum, the stock exchange had also passed an order whereby there were certain penalties which were imposed on the petition. Now, there is a GA, my lord, which has been filed by the writ petitioners challenging that particular order. So there are effectively
The main writ petition is there.
As well as the
has that merged into the next order, or it's on a different footing? These are different orders.
These are different orders.
Different penalties.
In fact, that is yes, and that is the reason why, my lord, this was also an argument which was made on behalf of the stock exchange.
Whether independent challenger.
Yes.
That argument still remains. I mean.
That argument still remains, my lord, because the division bench's order was very clear that this would be simply placed while the learned single judge is in session of the matter.
What would be the outline of your arguments?
One, the interlocutory application cannot be in excess of the writ petition, my lord. That is the first limb of the argument. The second is, they have said that there was no show cause notice issued. In fact, the show cause notice which was issued was bereft of the requisite particulars. So the principles of natural justice have not been complied with. Where we have said, my lord, several particulars have been provided time and again to the petitioners to come up with a reasonable cause which was required to be shown by the petitioners. And the third point was, my lord, that it's a complex question of fact and law which perhaps cannot be determined in a proceeding under Article 226 of the Constitution. So these are the three broad limbs of my arguments, my lord. If I
The
may,
complex questions of fact and law, so who should have decided? Civil court.
well, it ought to, because the evidence adduced in support of the contentions, my lord, that needs to be appreciated. That is the sum and substance of the third limb of my argument, my lord.
So regarding the first limb of your challenge, GA is not an appropriate proceeding.
Yes.
So nothing is required to be
At least
placed.
they were required to either amend or a fresh writ petition ought to have been filed.
Right. And so that does not require anything to be placed. But regarding the second point, you can place the notice if you have a copy. You can take the court's file. I mean, is it annexed to the first volume? No difficulty, I'll just follow you. I mean,
No, it has arrived. It has arrived. Just the fact that, my lord, the briefs would be opened after a long while.
no, because of the other previous matter which was going on.
Absolutely. In fact,
That I can appreciate, but not starting the matter, I cannot appreciate.
No, I will.
That is what I insist on. And however junior a person, you don't fall in that category.
No, I still
in
do
the
fall in
previous
that
matter.
category.
This is an explanation for the previous matter. I mean, you have to start.
Yes,
You have a
yes,
soft copy.
Absolutely.
You are in the matter. You have been appearing all along. You have to start the matter.
Absolutely.
I require only that for the part had to be kept alive.
Absolutely. Ma'am.
Because these are basically very small matters. I mean, very short few points. So we inflate that partly because of, I mean, certain facts have to be maybe placed. There are other compulsions. Court cannot understand. That is one of the factors also. No. Often that is one of the factors. I can't understand many things. I ask you. Court speaks too much. That also in my case. But beyond that, after a point of time, you have to conclude it. I mean, sometime. So why not do it? I mean,
Absolutely.
and I'll always permit you to put in a written notes of arguments. Don't go beyond your arguments. That's why I want the outlines of your argument.
And my lord, there was one more, since I've opened my brief, there's one more argument which was being made.
Yes, absolutely.
That my lord, there are bylaws of the Calcutta Stock Exchange, my lord, which also provides that there to be an alternative remedy by way of an arbitration. Because, my lord, if there is a situation, because the primary reason why this proceeding was initiated was there were several discrepancies in the documents which were being required to be maintained by the writ petitioner, that is the company, my lord. Now, according to the petitioners, according to the stock exchange, my lord, there have been
You were appearing online. Good to see you personally. Yes.
There had been substantial defalcation of funds, my lord, during the transactions taking place. And that was the reason why, my lord, the settlement guarantee fund had to be invoked so that the payouts could be made to the individuals who were transacting, my lord. So that those payouts were made out of the settlement guarantee fund, and in case of any disputes between the brokers, that is the members of the stock exchange and the stock exchange, in that kind of a situation, the arbitration would be invoked and the disputes would be settled by way of arbitration. That is in terms of the bylaws.
Did you take this point at the outset on your first opportunity in this petition?
Yes. Because, my lord, if your lordship recalls, Mr. Mukherjee had made submissions over 4-5 days. Thereafter, Mr. Rai was in rebuttal, my lord. He had made submissions on 2 occasions.
Well, it's not a Section 8 scenario in a writ petition.
No.
But you have to take it in the first instance.
Yes,
so if you have taken it and still you're arguing still,
yes,
you can take that point.
Yes.
And also whether that's an absolute bar.
Yes. But, my lord, for that, either the issue of jurisdiction has to be there or a issue of fraud.
Yes.
Either of these two makes it a nullity.
Or something non-arbitrable. In some other sense.
But in the present case, since the money had to be taken out from the settlement guarantee fund and paid off, so, my lord, the arbitration squarely and fairly applies in case of the dispute which has arisen by and between the stock exchange and the petitioners. Just gives me a moment, my lord.
Yes. Was Mr. Mukherjee's arguments centered around show cause notice not containing particular, or did he argue on merits also? I don't remember actually.
My lord, the arguments were made on that it
Mostly-
did not
mostly
contain
show cause.
particulars, and he had placed the show cause because the show cause notice itself, my lord, was very detailed. It had pointed out the transactions which were discrepant.
So did they challenge in the main writ petition? Did
No,
they challenge
no,
that
no,
show
no.
cause notice?
No.
Never challenged.
No. In fact, even in the interlocutory application, the GA, what was under challenge, my lord, was the subsequent order which has been passed by the stock exchange. So that is the reason why, my lord.
That is a minor reason, minor ground, because sometimes when you challenge a show cause, we say it's premature also. Courts say that it's
My lord, the
premature.
show cause notice, yes, but
Sometimes you do that.
eventually the show cause notice was never under
It's also
challenge.
fatal for them. But
No,
it's one of
but-
your arguments, yes.
No, the plinth of my argument in that regard, my lord, would be that the interlocutory application was much beyond and in excess of the prayers sought for,
No, that is
really
there.
sought for in the writ
Yes,
petition.
yes.
First, my lord, perhaps I would be required to place the writ petition first.
Very
First things first would be better, my lord.
But that has to be read in conjunction with the division bench order,
Yes.
which gave the liberty which you say
Yes,
is.
yes, yes.
Sometimes we say something, but the tenor of the order reveals that we gave you liberty to challenge that also. That's why I have
The
to
reason
look
why, my lord, I
Yes,
placed the
the order also.
order passed by the Honorable Division Bench also.
Yes.
I'll just quickly take your lordship through the writ petition once.
GA-টা কোথায় আছে গো? সাইডে একটা কোথাও রেখে দাও। তারটা না খুলে যাবে। Thanks.
Well, the prayers of the writ petition, my lord.
Yes, page 23.
Page 23, my lord.
But those were general in nature. Rescind, withdraw, cancel any decision to withdraw, to withhold excess security amount.
Yes. My lord, according to them, the base minimum capital was 4 lakhs. So the challenge in the writ petition was primarily, my lord, to the withholding, if I may say so, of any amount in excess of rupees 4 lakhs. Whereas the contention of the stock exchange at all material point of time, my lord, had been that the base minimum capital was much more than 4 lakhs. And that is the reason why, my lord, and since this proceeding was pending, we are not liable, my lord, because obviously the settlement guarantee fund might have been required to be invoked. So naturally, we were not ready and willing to my lord, disburse the balance amount also. But
Settlement guarantee fund is the handle you have on them.
That is the handle that I have. Because it would act, my lord, as the
Security.
security. Rather, my lord, the base minimum capital is the security.
Yes.
The settlement guarantee fund allows me, my lord, to invoke the specific provisions of the bylaws wherefrom, my lord, I can take the money, rather invoke the security which has been provided by the company with the stock exchange.
All right.
So, my lord, the first prayer was nothing to hold in excess of security amount of rupees 39 odd lakhs, my lord. B is a writ of for in the nature of mandamus do issue directing the respondent to forthwith cease wrongful withholding of the excess security amount, consequently allow the application of the petitioners to withdraw the excess deposit amount. The writ of or in the nature of mandamus, C, my lord, writ of or in the nature of mandamus do issue commanding the respondent.
Yes.
Yes. And certiorari.
He is releasing that.
Yes. Now the writ petition, my lord, I'll just quickly take your lordship through the writ petition once. What is important is paragraph 4, my lord, at page 2 of the writ petition. The petitioner number 1 is registered with Securities and Exchange Board of India as stockbrokers for carrying on the activities of buying, selling, or dealing in securities and carrying on such other activities as are permitted by stock exchange subject to conditions prescribed in the rules and in accordance with the regulations framed by SEBI. The petitioner number 1 carried on business as a member of the respondent number 1 and also other stock exchanges, namely National Stock Exchange of India and Bombay Stock Exchange. Now, on this point, I'll pause here for a moment. The base minimum capital in case of a stockbroker enlisted with only one of the stock exchanges is 4 lakhs. There's a regulation to that effect which has been annexed by the writ petitioners, my lord, to a supplementary affidavit which was filed before your lordship. I'll place that document. So naturally, it's an admission over here that the petitioner is enlisted and has subscribed with several other stock exchanges apart from the Calcutta Stock Exchange. So the contention that the base minimum capital is only a sum of rupees 4 lakhs is not tenable. Now, my lord, paragraph 5, I wouldn't bother your lordship, my lord. 6 onwards, the respondent number 1 is required to function in terms of the rules, bylaws, and regulations framed by the regulatory authority, Securities and Exchange Board of India, being pro forma respondent number 2, hereinafter referred to as SEBI. The Calcutta Stock Exchange has been asked by SEBI to initiate process. My lord, again, process the compulsory exit of the company as a stock exchange. CAC has litigated the matter, and the matter is sub judice before the Honorable High Court at Calcutta. Now, my lord, thereafter, my lord, I've also got instructions, my lord, at this juncture, because I should also my lord, indicate, my lord, one fact.
Yes.
That the exit program hasn't begun as yet, but the membership of stock exchange has been surrendered. Calcutta Stock Exchange has been surrendered. But at this juncture, since the list, my lord, in any event would remain, because
What has been surrendered, you said?
my lord, the fact that the
Membership has been surrendered.
yeah, as a recognized stock exchange, my lord, that membership has been surrendered.
So you no longer have recognition.
The exit program hasn't attained finality as of now, because SEBI has not sanctioned that as of now. But otherwise, because it's my duty, my lord, to indicate that also, because otherwise, I would be suppressing a fact, my lord, which I shouldn't, my lord. But nonetheless, that wouldn't have a
Since 2013, there has been no trading they have said. That is true.
No. Because the trading had been, my lord, had been undertaken through several other portals of other stock exchanges. And there were agreements entered into for that purpose, as in the Calcutta Stock Exchange was using the portal of Bombay Stock Exchange as well as the National Stock Exchange. So naturally, the trading had not stopped, but the portal per se, my lord, of the Calcutta Stock Exchange had stopped functioning. So that wouldn't be incorrect per se. In fact, that is within the personal knowledge of Mr. Mukherjee, because he has been advising the Calcutta Stock Exchange for that matter. But nonetheless, my lord, the issue crops up, my lord, at paragraph 10. I'll just quickly take your lordship through the writ petition once. Because paragraph 9 talks about the registration of the respondent number 1, my lord. That is the Calcutta Stock Exchange. 10, my lord. The Calcutta Stock Exchange, by a letter dated 9th May 2002, demanded inspection of the books and records of the petitioner number 1 for the period from 1st April 2000 to 9th May 2002. Such inspection was demanded to be carried out on 30th May 2002 at the office of the petitioner's company. CAC also demanded certain documents before carrying out the inspection. I'll just quickly take your lordship through the pleadings once, and thereafter I'll take your lordship through the documents. By letter dated 27th May 2002, the petitioner number 1 supplied the necessary information along with requisite documents that was sought by the respondent number 1, vide their letter dated 9th May 2002. An on-site inspection was conducted by the respondent number 1 and their officials on 30th May 2002 at the office of the petitioner number 1. The officials of the respondent number 1 inspected books of accounts along with other records of the petitioner number 1.
But you need not read the entire thing.
No, I'll just place my lord because very well. My lord.
If necessary, we'll come back.
In a nutshell, my lord, this proceeding had been initiated in the year 2002. Now, subsequent to this, my lord, there had been several exchanges of correspondences where the stock exchange has asked for documents. The petitioner says that they have provided the documents, whereas the contention of the respondent, that is the stock exchange, my lord, had been that whatever has been provided does not fulfill the requirement which has been put forth by the stock exchange to the writ petitioners. Now, my lord,
What happened in the order which was challenged in GA? In the GA, I mean, what was that order?
over there, my lord, there had been several, in fact, around 2 crores of rupees, my lord, which the petitioners have been directed to make payment of.
So that is in connection with the same continuing default. It's a continuing default on their part.
No, it's not. It's not a matter of default, my lord, because the
Default
issue,
in the sense they did not comply with non-compliance.
no. There are two parts of it. One is, my lord, the investigation which was initiated because there had been fraudulent transactions. That is the contention of the stock exchange. There had been fraudulent transactions, so naturally we were inspecting their accounts and the documents which they were required to provide, they were provided, not provided.
That can culminate in in penal action under the law.
That is what I'm on, my lord. Both are two separate independent actions.
So one is on the investigation on the fraud and the other is non-compliances. For non-compliances, what did you do? What is the penal measure?
Somewhere down the line, the non-compliance coupled with the discrepancies merge into the entitlement of stock exchange to invoke the arbitration in terms of the settlement guarantee fund and the bylaws which can require the stockbrokers to make payment to the stock exchange.
No, not that. I mean, arbitration or no arbitration. I mean, what is the penal measure you can take? If they don't comply with provisions, then you can strike out their name.
We can strike out their name and we can also impose pecuniary measures, my lord, wherein the stockbrokers would be required to reimburse certain sums of money in favor of the stock.
So when the writ petition was filed, you had written to them asking for those?
No, we have asked for, from the writ petitioners the set of documents in order to complete.
They have been continually not complying according to you. They have not been producing the documents.
That is what their contention had been, that the investigation was pending for a substantial period.
Yes, but how could you withhold without, I mean,
Because they were still stockbrokers over there with the stock exchange. So naturally, the base minimum capital was required to be maintained. In any event, the base minimum capital.
So their allegation is over and above that you have also been withholding.
No, that is what my contention
So you say it was never withheld above the base minimum.
No.
That's very well. Otherwise, did you have the power to withhold beyond the base minimum? I don't think so. You are not entitled. You don't have a lien on that.
That has never been their contention either. Why I say so, my lord? Because perhaps, my lord, I'll take your lordship through the documents because I'll indicate 2004. In fact, my lord, there was a list of dates which had been filed. Perhaps that will assist. That might assist your lordship, my lord. Perhaps this will assist your lordship, my lord. I'll just quickly take your lordship through the dates. Because proceedings had been directed to be initiated at the instance of SEBI against the writ petitioners on several occasions.
So why is the cause of action different in the GA? That is what I can't understand. It's a continuation.
In the GA, my lord, it is the final order which had been challenged.
Yes.
In the investigation proceedings, but the investigation proceedings was never under challenge in the writ petition. The writ petition
Your
was
ground,
solely
what was your
directed-
defense in the writ petition? Why were you withholding?
Because there were two grounds. One is that the base minimum capital is way beyond the sum of rupees 4 lakhs, and which was required to be kept deposited with the stock exchange.
Yes.
And the second part is, my lord, that I wouldn't rather, because the petitioners were required to continually maintain that particular sum of money, the base minimum capital, with the stock exchange as long as they are members. Now, subsequently, what they have sought to do is, my lord, to withdraw their membership, surrender their membership rather. That membership, in the event stands surrendered, then the writ petitioners would go scot-free. I would be required to make payment, my lord, of the base minimum capital. So whatever amount of money which the stock exchange would be required to realize.
So the premise of your refusing their surrender prayer was the investigation. So that was culminated in the order. Why shouldn't they challenge it in the same proceeding? It's a series of causes of action. I mean, if it's also connected not only with the cause of action of the writ petition, but also the defense. Because your defense is, one of the defenses is that no, you cannot surrender, because they also complained in the list of dates. Also, there's a complaint regarding their surrender not.
The list of dates is at a much later date once this challenge has been put forth.
No, they refer to pages that those are annexed, that they asked for surrender.
No, those have been annexed, my lord, to the GA, not to the writ.
Page 11 of the list of dates.
Few documents are there, but not all of them, my lord.
Please come to page 11 of the subject, item 44. Till Mr. Rai gets mentally prepared.
No.
Item 44. So that's reference to the writ petition page number.
Yes.
And from 46, GA starts. No, not GA starts, only that.
My lord, 44 also, it's the refund of excess deposit.
Item 44.
Yes.
20th August 2018, petitioner wrote to the respondent twofold. Refund and initiate action for surrender of membership.
So no challenge. There no challenge.
Answer.
It was always, my lord, related to the refund of the excess deposit.
So investigation was also one of the grounds for.
Yes, it was going on. And that was the reason why we had not disbursed that sum of
money. Now that has culminated. Now they challenge that also. It's a necessary corollary, because if that stands, you say they ought to have filed a separate writ petition. I'll direct them to put in the court fees for that.
That is, I'm always at your lordship's hand regarding that.
But is that too technical? I mean, they ought to have filed a main writ petition. Even if I hold that, I'll just direct them to
amend the original writ petition. Amend the original writ petition to an extent, because perhaps if their contention
is this to be an amendment, no difficulty on that. And how much is the court fee payable now? 220 rupees or something.
Perhaps somewhere around that amount only.
So they'll
I'm not very sure about that.
Instead of penalty, that will be a better thing for them. So the first point can be taken care of. Second point, show cause notice particulars not given. Yes, you have to argue on that. And this complex question and bylaws arbitration, these are valid.
And the fourth point would be obviously the alternative remedy, which was
yes, that is the fourth point. The bylaw, sorry, I refer to bylaws. Bylaws provide for alternative remedy arbitration.
Yes.
So argue on this, place the notice, argue on the other points. If you have to cite any judgment, you cite that.
Several judgments we have been carrying would have been submitted, but none.
There has been a miscarriage of those judgments.
Long time, non-carriage of judgments.
You have forgotten the judgments, sir. I mean, the list is there. The list is there. Refer to those and just give the paragraphs and that. Mr. Rai is doing precisely that, so he'll just. It's a logical culmination of that.
That's the reason why seniors are always required. With the leave of.
Yes, Mr. Rai is ready. Yes.
Becomes very difficult, suddenly when
yes,
No, I understand the local matter. I mean, created an apprehension.
But we always keep watch. And your lordship has been on this side. Well, we understand.
Fully understand.
Reach, it will not reach.
And I fully understand what would be a trigger for you to move. This is the reason all of you are here now.
This was a trigger.
Otherwise, I would be having coffee by now.
I know, Malin.
No,
And I was gauging your lordship's mood on
one matter I've cancelled part 3 occasions, time taken, and
I was gauging your lordship's mood while I was in the car itself, my lord.
oh,
I did not
all right. Now you have become it's a stock exchange also, stocking.
Maybe shopping also, my lord.
Stocking also. Stock HTALK exchange.
My lord, your lordship has seen, my lord. কোথায় যাচ্ছ তুমি? যাবে না এখন কোথাও?
4 points have been enumerated by
Yes,
your
my lord.
learned most competent junior.
My lord, very.
The 4 points are these. If you have to add anything on the points on the outlines, first is that the GA is not maintainable as an interlocutory application, because that's probably you can take care of that, which you expressed and you heard.
My lord, that I will, as a matter of fact, argue at the very last.
Last point.
Last
The
point.
show cause notice particulars, you say there was sufficient particulars for them to understand what was there and
My lord, not only that, my lord.
to what to reply on.
They answered also.
The answer also very well.
They answered with full
But
guts.
they answered also.
Yes, my
Very,
lord.
very.
The last occasion, my lord, I pointed that out,
Yes.
which my lord, were several moons before, but my lord, that was the
That is one of the other
my lord,
points.
what Mr. Sengupta took the point of that writ and the scope of the writ, my lord, I'll be very candid. One small point, my lord, he just said that there's an arbitration clause.
That is another, yes.
My lord, it's linked. Why I say this, my lord? First of all, my lord, show cause notice was challenged. Show cause notice, sorry, the show cause notice was not challenged. Was not challenged. So it's a separate cause of action. Now, my lord, I'm not on that also. Separate cause of action merging with his lordship's order. My lord, my reading was a bit different. Your lordship, what fell from your lordship, even if I take that, my lord. But what has happened today, my lord, there is a order. That order has several disputed questions of facts and whatever it is.
3 points. The first point was that GA, separate GA. Second point is notice particulars. Third was complex questions of facts and law, and evidence is required to be appreciated. So should go before
arbitration.
Either a civil court or arbitration, depending on the fourth point.
Since there is a clause,
Since there is
I'm saying that is why I say, my lord, this part of the order, which even if it's allowed to be challenged before your lordship, my lord.
No, what one of the challenges is arbitrable, the other is not.
But it can be. I'll point out why, my lord. I'll point out why. My lord, the main challenge was, my lord, if your lordship kindly appreciates, that I was not giving back their security money.
Excess, they say.
That is the only point.
That is the only relief sought at least.
Only relief. My lord, that had nothing to do with regard to one on the face of it. It had nothing to do with this dispute, which now has.
No, they referred in the writ petition to your defenses also, in a sense.
They couldn't have.
No, because why do I say
May I just
the correspondence between you? They wrote to you to
yes, correspondence is, but Malak, that has not been made the cause of action. The cause of action is, yes, there was some investigation. I have then thereafter told them, that is why they have said so. I have thereafter applied to them saying that I do not wish to be a part of a stock exchange, keep whatever the minimum is supposed to be given, and I'm leaving. So the cause of action is I am retiring as a member. So whatever little I'm supposed to keep under the rules, you keep it, and the rest you give it back. Not the point that the investigation is continuing on the basis of that investigation of withholding the money. No.
Or any challenge to that investigation?
No. So therefore, my lord, when this comes into the picture, the main order, my lord, which now is being looked into by your lordship, my lord, there I say, my lord, that becomes a disputed question of fact and law and evidence, which, my lord, is covered by the arbitration clause. This is what I have to say with regard to the technicality of whether the GA needs to be amended or not, my lord. I'm not going into.
So these are linked.
These are linked.
Arbitrability and.
Yes, because of the disjunctive portion of the cause of action made out between the trial court and the appellate court. So that is the scope, my lord. Now, my lord, may I just straight away, my lord, take up the. কতক্ষণ আসবে?
Because solicitors have offices, they should have kept the files at least in the office. And,
yeah, I have mine.
And your solicitor is so competent, he can argue himself also. So he should know that he should have kept it in his office at least. Well, I have worked with him, I know how competent he is. So he should have it in his office itself.
As a matter of fact, he was one of my first briefing solicitors in my profession.
Maybe in my case also, I don't recollect exactly, but yes. But He knows that a copy at least should be there in his office, which should be brought by now.
Huh? There are many difficulties, and the clerk is not
Other
there.
difficulties.
Malad, may I just point out, Malad, the points which Mr. Mukherjee has, I'm going to address.
Yes.
First says that there is no show cause notice. That is what is specifically submitted. And the show cause notice is bad because it does not mention any consequences. Now, what people do? Then he says that there was no power to impose any compensation because it is barred by the Securities Regulation Contract Act. The next submission is there is violation of natural justice since the inspection letter, inspection report was not provided. But I'm just narrowing it down, Malad, so that Malad, I can address also in that fashion.
You're right.
Then he says that there was a subcommittee meeting of 24th November 2008, and this decision in the subcommittee meeting was not communicated. And he says that in 2008, when the subcommittee meeting was held, there the finality arose, and anything thereafter is an afterthought.
All right.
Next point, he says that SEBI has given them a clean sheet.
Another is the 2018 inquiry letter gave a go-by to 2008. Something was mentioned.
That would be my submission.
No, his submissions and afterthought, malicious.
Yes, that is what I said, Malad.
Institutional malafide, that was the term he used.
Yes, institutional malafide,
advantage of single judge order. Yes. So our notes are telling. And because of the fact that I was also a lawyer. And SEBI report gives clean sheet, as you say. Exactly what you say.
Yes.
And
then he takes the point of quorum non juris.
Yes, quorum non board of directors of CSE.
And
why was that taken exactly? What was his point?
He was saying that the directors, they were supposed to be an independent director. The directorial composition was not correct.
Right. And
lastly, he took a point, Malad, that it's on a point of fact, Malad, saying that to show that it's a malafide, saying that it's not, the order was passed post the 15 March order of the division bench, since it was communicated on 1st of April. So as if that it was made subsequently and then handed over. Now, Malad, may I now show your lordship, Malad? But as a matter of fact, we have all been following the GA1, Malad, because as I said, Malad, the writ petition, your lordship will not find anything. So GA1 is the main Malad petition, Malad. Kindly comes straight away, Malad. And if your lordship wants, then may I place the notice, or your lordship is aware
notice,
that
just
very cursory, Malad, very cursory.
Yes. Do that.
বলো না কোন পাতায় আছে একটু বলতে থাকো, পাতাগুলো বলো, আমার পাতাগুলো নিয়ে একটু প্রবলেম হচ্ছে.
What was the date of the notice?
Yes, sir. The date of the notice, just gives you a moment. Namanti एदिके आए. 24th
April.
No, 24th April 2002.
Yes, I've got it.
Huh? 4th March?
This is a SEBI letter.
No.
This is a SEBI letter.
But
this is the genesis of the inspection.
Yes,
That's
yes,
my note. Yes.
But 4th March is the show cause notice as told by them, Malad, or submitted by Mr. Mukherjee. Malad, my submission is there is no show cause notice. There is no provision of any show cause here. So, Malad, may I just start, Malad? Kindly takes, Malad, Annexure D, page 75, 76, and 77 of volume 1 of GA number 1. This is a letter of 10th September 2001. Volume 1 of the
Yes.
opposition. Yes. Just give me a moment. I'm just getting my.
Absolutely.
I'm so sorry, Mallet.
No, you just arrange your bearings.
Volume 1 तक होता है. It's volume yes, भाई चलो. Mallet, page 75. Mallet, this was in reply to a letter which the SEBI had written on 7th September 2001, which your lordship will find at page 73 and 74. May I start from there, Mallet?
Better. Yes.
Mallet, this is a letter written to them where SEBI says that you are advised to furnish the following details with regard to your dealings, and says, Mallet, about addresses of group and associated companies, clients, copies of general ledger, client-wise settlement, monthly statement, carry forwards. These are all on points which I have investigated upon also. Then Mallet, settlement-wise total in paid, daily transaction, demat statement for the pool account, and everything, Mallet, whatever they said. Thereafter, to reply to this, Mallet, on 10th September, Mallet, they gave a letter which is at page 75. And they say that they are giving and furnishing the details. So details are furnished. And after that, Mallet, also 14th September, they also furnished a few other letters. Then Mallet kindly takes the document at page 62. Of that volume, Mallet.
62, yes.
62, Mallet. This is, Mallet, a letter issued by the SEBI to the Calcutta Stock Exchange. This is the genesis, basically.
Yes.
SEBI has conducted investigation of Singhania Group, Khemani Group, Poddar Group, and Biani Group of CAC brokers as a part of investigations the role of Mr. Ketan Parekh. So, Mallet, this all involves, Mallet, this is a very well-known issue, Mallet. So,
but these people have nothing to do with Ketan Parekh. Ketan Parekh is here also.
Ketan Parekh, this was all a scam which was being looked into by the SEBI. That is why Mallet kindly sees Singhania Group, that's number one. Khemani Group, Poddar Group, and Biani Group of CAC brokers are part of the investigation.
These are the Dalmias.
Mallet, they are linked. Singhanias and Dalmias are linked. That link was what was supposed to be Mallet unearthed, if I say so. Sorry, Mallet. In the rule and his associate entities in the market manipulation during years 99 to 2001.
Did you read Biani Group as Biani?
Biani, I said, no, Mallet, I would have said otherwise. I did.
Yes.
I did.
It always happens to me for the first time.
On examination of the data provided by the four group of brokers, it is observed that they had indulged in large-scale transactions with the other brokers of CAC. Now, Mallet, this is where it comes in. And other stock exchanges which could be off-the-floor transactions. This is one of the allegations. The exact nature of those transactions, whether they were off-the-floor transactions, could not be traced from the data of the Poddar Group, Singhania and Biani Group due to non-availability of original records. However, it is found from the source data of Sauda books provided by the Khemani Group that the transaction ID and transaction time are not appearing in certain transactions which could be identified as off-floor transactions.
This is the matter where Mr. Mukherjee right now remember that he argued that it was through National Stock Exchange and others. So these are not off-the-floor transactions as such.
That is what he said, Mallet.
But
I said that the records you have not brought on record.
Yes, you said that.
That I said, Mallet. As per the data provided by Khemani Group, the done of the floor turnover around 593 crores and rupees 11,248 crores, very big amounts, Mallet. These off-the-floor transactions were mainly done on behalf of Ketan Parekh entities and on proprietary accounts. Many of the counterparties to the off-the-floor transaction were the brokers of CSE, and some brokers of other stock exchanges have also acted as counterparties. So SEBI, Malad, focused on the Calcutta Stock Exchange and the brokers of Calcutta Stock Exchange. As per the information provided by CSE, the aggregate total of off-floor transactions reported by Khemani to CSE during 2001 to 2002 is only around rupees 301.02 crores, despite the fact the obligation to report the off-flooring transactions is cast on the brokers. As per the information received from CSE, total off-floor transactions reported CSEA is only around 1295 crores. The names of the brokers and the off-the-floor transaction reported by them is given below.
Calcutta probably has the largest number of shell companies.
Yes,
I was reading somewhere.
yes.
I mean,
Very sad, Malay, because this was the stock exchange.
the money does not percolate below that. That is the sad part of it.
Very
If it
sad.
percolated, then we would be a rich state.
Yes, Malay. Things are very sad, Malay.
Things are sad. We have to make them happy. By default, things are sad.
So, Malay, a list of the flow transactions
Yes,
they found has been provided, which only talks about what has been declared.
This is there of the flow transactions.
What they have, no.
Not there. In that
They
investigation,
are
this
saying,
came up.
yes, they are saying many of the flow transactions have not been brought on record. And they are saying it's only 1295 crores which has been brought on record, and this is the list.
They are not connected with any of these.
Not as yet.
All right.
They are trying to, SEBI is trying to find out who has
Yes,
been.
yes, it's an investigation. So
No. Well, maybe just transaction. I'm just trying to, whatever I have understood.
Yes.
Not my forte at all. I would have allowed my senior in this. Well, what they are saying is that it was a duty to inform off-flow transactions. In off-flow transactions, with Ketan Parekh entities, there has been some kind of a foul play. They are saying the off-flow transactions that recorded by CAC is only these and not others. And thereafter, it may be observed from the above list that Biani and Poddar had not reported any off-the-flow transaction to CAC during 2000-2001. And DK Singhani had reported 7.38 crores as their off-the-floor transaction during 2000-2001. Most of the brokers listed above were appearing as clients in the books of above mentioned 4 groups of CSC brokers investigated.
Mr. Tell me something. Off the floor transaction is otherwise legally valid, but it has to be reported to the stock exchange.
Yes.
Right?
Yes.
Very good.
Off-market trades are those trades that are executed outside the purview of exchanges' online trading system. In off-market trades, funds are transferred from one bank account to another bank account, and also shares are transferred from one demat account to another demat account.
You're reading from where? Somewhere else?
This is my note.
Yes. I'll require that actually. Yes.
I will try and.
Please just provide the
Because I also wanted some information from
yes,
them.
a printout from.
I will give it, It's on a printout only, I wanted to know what is the meaning of khate pate account, because when you
Yes, khate pate was explained by Mr. Mukherjee, but
that's why I wanted an explanation from the stock exchange also.
my range is up to khate pite, but khata pita, but khate pate is not my.
Pate, there is not khate pate.
Khata pate.
It's khata pate. And off-market transactions, funds transferred to journal entries.
All right.
Synchronized trading and circular trading. I took information on what are these.
All right. No, that basic concept is there.
Yes, I don't have it, so that's why.
Circular trading it comes obvious, yes.
But here, it is just that it is not cleared through any clearing corporation. As in the CSC, therefore it's offline. Now, kindly sees, Securities Contract Regulation Act 56 permits spot delivery contracts outside the trading and settlement system of recognized stock exchange. Spot delivery contract has been defined by Section 2(1) as a contract which provides for actual delivery of securities and the payment of a price therefore either on the same day as date of the contract or on the next day. But this is not allowed in forward contracts. I'm not going into that. It's another chapter. As per SEBI circular of 1999, all negotiated deals, including cross deals, are prohibited. So, and all such deals shall be executed only on the screens of the exchanges in the price and order matching mechanism of the exchanges, just like any other normal trade. The above decision was taken as negotiated deals avoid transparency and do not contribute to price discovery. As the original records and books of records were not made available, the nature of this transaction could not be verified, could not be ascertained. Then, my next paragraph, it may be mentioned out of the total number of around 450 active brokers of CSC, 286 brokers of CSC had done offloading transaction, mainly during the year 2000-2001. Malan, what has happened, Malan, kindly appreciates the circular was of 99, where Malan, this off-market trade was put to a stop. In spite of that, subsequently, Malan, 2000-2001, this was continued. That is what SEBI was looking into. Now, Malan, that paragraph in my second line, it has been decided that the top 25 brokers who have done off the floor transactions with Singhania Group, Khemani Group, Poddar Group, and Biani Group of CSC would be inspected by Eastern Regional Office of SEBI and the remaining brokers by CSC. Malan, may I just wait here for a moment? So, Malan, CSC was going to also investigate and SEBI was also going to investigate.
First stop, go to the SEBI and yes.
First 25 would be by SEBI and then the rest by CSC and other respective stock exchanges. It appears the brokers of CSC have violated the following provisions, and I'm not reading that at this moment, not necessary. Then, Malat, join to follow the list of this. Malat, next page 65. Malat will kindly see why we are all bothered about the offload transactions, Malat. Malat, just after, as per regulation 7 and the bullets thereafter, indulging in the offload transaction, Malat, at page 65.
Yes, indulging.
In the off-the-floor transactions, at huge volumes and without reporting or reporting on a fragment of said transaction of the brokers to the exchange amounts, to creating a false market or a parallel market outside the recognized stock exchange. It's just like black money, Malat, black money and white money. It's more or less like that, Malat.
But after crypto, what will you do?
Well, crypto is not recognized in our country.
You go on not recognizing
but
it.
everyone is making money. Everyone is making money.
More than a parallel economy.
Well, I think at one point it might become the
Has to be recognized.
Has to be.
And regularized. Regulated.
Regulation is very important.
Regulation is very difficult. For that, the international, there has to be an international collaboration, and the people who are behind it, they have to be put in charge.
They don't want to do it. And the only problem is, Malat,
incentives should be anyway. We are not economists.
Because Malat, there are so many persons who are into programming, Malat. You cannot control all of them.
Let us forget that. So long as we have something to wear, roof over our head, and something in our stomach.
Absolutely, Malat. And that's what I thought, Malat. Today, Malat, I was very candid.
There's no end to this.
But I for some reason, I just could not get up in the morning.
Today,
Malat, I just couldn't get up in the morning.
Maybe this matter.
When I got up, I'm completely dozed off, Malat. Then when I got up, I thought it was 9:30 already.
Work pressure, work pressure. You work
that's what I
through nights and all.
Some good sleep is very important also.
Council's lives are, so stressful otherwise.
This is the first time in my life where this happened.
It may happen anytime. It just, it's a default mechanism of your body to protect itself.
Now, Malat, kindly sees, Malat, page 66.
Yes.
A list of names of 261 CSC brokers and 2 of their sub-brokers, other than the top 25 who had indulged in the off-the-floor transaction, above 4 groups of CSC brokers is enclosed as Annexure 1. Now, Malat, kindly sees. I'll straight away take it to page 67, Malat.
Yes, because these are general.
No, Malat. This is a very important sentence, Malat.
No, up to page 66.
These are general. Why they are doing it, they've said
yes,
so.
Yes, absolutely.
And no, Malat, one thing was important in 65, 25 and the others to be investigated by the SEBI and
related with Ketan Group and all these things.
25
the link was
SEBI,
given, yes.
And the rest by?
Yes.
And therefore a list is now being given.
So this is a merit list. Yes. The first 25 qualify for them.
This is not the first 25. The rest after this.
From 26 onwards.
And 54 is the one of the ranking of my learned friends on the other side, client.
So this additional code fee for the GA should be waived. If they don't have that status. We put in additional code fees.
But that is what I wanted to show. 54.
54 years.
Is Dalmia.
Their name is there, right?
And Malat, I was supposed to be investigating them.
Yes. Yes.
Because Malat, Mr. Mukherjee has taken a point, SEBI has given a clean sheet.
Oh, right.
So they have
SEBI clean sheet was after this probably.
yes, but I was
It was never supposed to investigate.
and I was continuing with the investigation at that point in time.
SEBI itself,
Not
SEBI itself entrusted this duty to carry on the investigation.
may I just point out,
SEBI itself gives a clean sheet. Then
SEBI, what clean sheet has SEBI given?
that is
SEBI
not so clean.
Whatever it has given on its own basis. But why carrying out this investigation? I find that they have acted contrary to my circular, my my bylaws, my lord. That is what has happened. It is just not limited to that. They have acted contrary to the contract which they have with the Calcutta Stock Exchange.
All right.
My lord, every broker has a contract. It's
Yes.
a pure contractual obligation, my lord. The dispute is also contractual. It is absolutely contractual.
Which contains an arbitration clause.
Therefore, it contains an arbitration clause. It binds everyone. It's not that it's only a violation of SEBI. From here, everything transpires.
So during the investigation, these were also
Yes. And Malad will see that it would appear from the face of it what transactions have happened and whether I had a right or whether I should have continued or not. Your Lordship will find that. Malad, may I just take your Lordship there? 4th March, 24th April. No, 26, 27, the petition. Malad, I will just place, Malad, your Lordship kindly takes a writ petition once, Malad. Malad, this is this letter is more or less that is what I wanted to show, Malad. Again. Malad, just one thing, Malad, I missed out, Malad. Page 66, Malad, once more.
Yes.
Malad, just this after the list is provided, Malad, CAC have to be critical. CAC has is advised to inspect the broking entities given in the annexure 1 who had indulged. Well, I'm just not reading that.
Yes.
Malad, just somewhere in the middle, in order to ascertain, if your Lordship gets it, Malad, between the brokers of CAC and other stockholders, in order to assess the nature of transaction entered between brokers of CAC outside the trading system of CAC, and to find whether any provisions of the Securities Contract Regulation Act, Stockbroker Sub-Broker Regulation, SEBI Circular, Articles of Association, and bylaws of CAC, notice and CAC or any other law have been violated.
So you come in on 2 counts. The very first thing is whether there was any off-flow transactions in your trading system and your violations.
Articles of Association and bylaws, both.
Yes.
So SEBI only tells me. And who would know this better than me? And thereafter and initiate appropriate action which will act as deterrent against them.
Yes.
Manad, it has also advised us to take even criminal
police authorities.
Conspiracy, anything of that sort, Manad. Now, Manad kindly comes to page number 26 of the writ petition, Manad.
এই রিট পিটিশনটা কোথায় হয়? জিএ এটা পুরোটাই কি জিএ না বুঝতে পারছি দেখো তো এটা কি রিট পিটিশন?
না ঠিক আছে
তাহলে এইগুলো জিএটা আবার কি সাইডে থাক? Yes.
Well, 26.
26.
And I'm just relating to very quickly because it's been a long time that these.
No, absolutely. This is that notice.
Well, yes, not this one. This is the first. Well, not the notice which they were. I don't think they've challenged also, but the focus. Notice of focus is not this.
Not this.
We write to inform you that the inspection of your books and accounts, other records and documents will be carried out by CAC on 30th May at your office for the period from such and such to till date. Stock exchange reserves the right to carry on the inspection for any other period with prior intimation to you. So, my lord, what were we doing? We were carrying out an inspection. You are therefore advised to keep the required information. Then, my lord, kindly sees the fourth paragraph. Inspecting authority, the concerned CSC officials shall be entitled to all such acts, deeds, and things specified in SEBI and bylaws of regulations of Calcutta Stock Exchange shall be obligated to impart as a registered stockbroker to Exchange Corporation furnish such information. Now, my lord, these are what has been sought for. Then, my lord, kindly sees.
Mr. Mukherjee had also taken a point that there was a lull between 2004 and 2018.
Yes, my lord.
So in between, you did not do anything, something of that sort.
And I will point it out.
This
my
is
lord.
that
There were
2004.
there were proceedings which they had initiated, my lord. Therefore, we had kept quiet.
Proceedings against you.
Yes,
Suit.
suit.
Who had initiated?
My lord, they had initiated the suit.
The present petitioner.
Yes, and then they withdrew the suit.
No, why did you keep quiet? I mean, there was an
My lord,
injunction order.
No, there wasn't. My lord,
When they file a suit, you
yes,
keep quiet.
they kept quiet. Well, that is something which I cannot explain, but that is what they did. The suit was filed. Once the suit was withdrawn, they started off again.
So they should have filed a suit this time also.
No, my lord, this time I think we should have. Then they would have kept quiet. Now, my lord, kindly see.
We have written, Mr. Mukherjee actually had touched upon these also. So you had carried out inspections. These were.
No, my lord, there are 2 points because of this.
Achha.
Today, my lord, when Mr. Mukherjee says that I am challenging the authority of CSC to carry out this, whatever it is, and I say he conceded to it.
Submitted to the
jurisdiction. And my lord will kindly keep note. My lord will come back then.
Just come back.
আমার হারিয়ে গেল এইটা কোথায় গেল So my lord, I was at page 26 and 27. Mr. Mukherjee has placed it, but my lord, I'll just point out a few of the clauses. My lord, kindly see clause 14 at page 27.
Yes, 14.
Dealing with brokers so far as off-market deals are concerned, the following format in hard copy as well in soft copy. This was sought for. Then 15, also please provide the following as required by SEBI by its letter of 1998 business volume handled by you in the following format. Then my lordship will find bullets. Last two bullets, details of that's a khate pate or khata pata account with different brokers or clients, fund transfer to journal entries. These were not provided, these two. These two were not provided, there are subsequent letters for that. And the very last paragraph, para 17, at the time of inspection, you or your representative should be able to provide all records are mandatorily maintained by you at your office in respect of know your client subject. You are aware that such will be maintained as per SEBI circular regulation, and it shall remain the prerogative of the exchange officials to inspect any other related books and documents of your firm as shall be deemed necessary during the course of inspection. Now, Malat, in reply to this, Malat, kindly takes the next page, page 28. So, Malat, two things. The initiation is not disputed any further. That they did not understand the meaning and scope of the inspection is also not under question, because kindly see the next page. As requested by you, please find enclosed. Malat, at J and L, J and K, Malat, your lordship will find how they've dealt with that khate pate they don't have. It's a normal account ledger. And fund transfer through journal entries, normal course of accounting, there are many journal entries. And as such, particular journal entries during the fund transfer cannot be handled. Then Malat kindly takes Malat, page 14 of the writ petition, Malat, where Malat 30th of May 2002 on-site inspection was carried out. Admittedly.
Page 14.
14 of the writ is the pleading, Malat.
Yes, yes.
Paragraph 12. They say that
paragraph
12.
Paragraph 12
of the writ petition, Malat.
That is not page 14. Paragraph 12 is page 4. Online site inspection of 30th May.
Page 4, Malat.
Very well. Para 12.
Sorry, Malat.
No, whatever. Para 12.
Yes. Then, Malat, kindly takes annexed E, page 79 to 80, Malat, of a letter of 6th August 2002. Malat, kindly takes it. It's at in the GA, Malat, volume 1.
It's a 1.
আমার হারিয়ে ফেললাম as usual.
মাইন্ড চেঞ্জ করতে পারে বল তুই এটা না ঠিক আছে এটা না হলো না আমি নেব
ভলিউম 2 ভলিউম 1 টা কোথায় গেল এইটা
1 টা 2 হয়ে যেতে পারে
excuse me. This is what they have, but this is what was relied upon by Mr. Mukherjee. But this is a letter issued by SEBI.
Which page?
Sorry, page 79. Minute.
Yes.
And this is of 6th August 2002. And the subject is, if your lordship kindly sees, Malat, it's a very general subject, inspection of books of accounts. It does not, Malat, in any way refer to that specific Ketan Parekh investigation. See, Malat, it isn't decided that an inspection of your books of accounts, other records and documents will be carried out by jails and...
This is the clean sheet.
The next will be the clean sheet, Malat. This is the initiation. The next is the clean sheet. And I will show that the SEBI thereafter wanted a cleaner sheet. So I'll try and show that so that I can take a defense against what is clean chit theory, my lord. So, my lord, suddenly an inspection of books and accounts will be carried out. And, my lord, kindly see the generality of 1, 2, and 3, my lord. The last paragraph, the inspection shall be carried out under the provisions of Regulation 19(1) of stockbroking. The concerned chartered account shall be entitled to all such acts and deeds as required. So, my lord, your lordship will find it does not specify any specific time period, any specific, my lord, investigation related to Ketan Parekh and the Calcutta stocking does not refer to that. Next, my lord.
But SEBI may decide not to put them on notice as to the particulars of the investigation. Because this is not something which is castigating, it's an inspection.
Just an inspection.
Might not put them on notice in this letter that this is the Ketan Parekh incident.
They did not, because it was a general inspection.
No, what I am trying to say is the opposite.
My lord.
It might not have been a general inspection, might have been, but we don't know. Might comes in. Might may not be right.
Yes, because, my lord, SEBI always has a right of inspection.
True.
And, my lord, kindly appreciates two more things here, my lord.
Yes.
SEBI specifically gave that investigation to the Calcutta Stock Exchange themselves, giving that list.
True, that remains.
So now, when if your lordship after that, but reads it together.
Yes.
So I only deduced, well, this was not in respect of that Ketan Parekh investigation.
SEBI, is it within the jurisdiction of SEBI normally to undertake inspections? Because
well, that's what they've given Regulation 19(1) of SEBI, Regulation 1992.
So there's a general power of inspection also.
Yes.
So you say this was a general.
General.
Very.
General. Well, it does not talk about any offline transaction, anything of that sort. It only says books, whether there has been provisions have been followed, and what adequate steps for redressal of grievance of investors are being taken. This was never a part of that inspection. Now, my lord, 2nd January 2003, my lord, from page 84 to page 129, my lord, is the report of this Mr. Sen Gupta, my lord. That was provided to them.
Yes.
And, my lord, will kindly see, it is there, my lord, dealings with clients, segregation of bank, collection of margin, regulatory requirements, everything, my lord. First recording, my lord, at that, my lord, at 2.1 is records of times of orders placed by constituents have not been maintained and also not reflected in the contract notes. As a generality, SEBI found this. My lord, vis-a-vis their statement, we don't have offline, we don't have the journal entries, we cannot identify the the online transfer details, my lord. I showed in their letter to the reply. My lord, so, my lord, I say that this was only related to this general inspection. My lord, a report, a letter was sent. My lord, that kindly sees page 130 now, which will be volume 2, my lord.
So 1 second, what was section 19 was quoted?
Yes, my lord.
Where is that?
Well, may just
page.
Well, that page is, my lord,
73.
Page dilam na,
What is the section quoted?
No, inspection jonna bolbo. Well, just give me a moment.
Yes.
It's 19(1), my lord. Page 79, my lord.
79.
79, the last paragraph. Inspection shall be carried out under the provisions of Regulation 19(1) of the SEBI Stockbroker and Subbrokers Regulation 1992. Now, my lord, My lord, has your lordship got the list?
And the
of-
report also, page 84 says report is under regulation 23.
Yes, my lord.
So we'll have to look into those regulations later
But
on.
I'm just,
To show whether those are general or
my lord, I'll show that.
later on. Yes. You are placing something?
Yes,
GA.
my lord. I was only, my lord, my lord, your lordship would be having a list of dates. My lord, is it with your lordship, my lord?
List of yes.
Yes, my lord, I'm following this. So, my
Right,
lord,
right.
that will
It
be
will be
easier.
easier for.
Yes, my lord. I'm following their case, my lord. I will show my documents subsequently, my lord.
Very good.
My lord, then, my lord, your lordship will find the entry in the second page of the list of dates is 9th May 2002. My lord, I will just come to this a bit later, my lord. My lord, straight away, your lordship will kindly take, because I want to put a stop to this, my lord, part, oh, sorry, page 3, my lord. This part of the, that SEBI had exonerated them and therefore we should not proceed. My lord will kindly jump serial numbers 11, 12, 11, straight away comes to 12, which is annexure E, page 135, 136. This is the letter which Mr. Mukherjee says is the exonerating letter. An inspection of your books for the period from April 2000 to August 2002 was conducted by SEBI during the year 2002. Now, my lord, another thing I missed out, I should have mentioned that. I'm so sorry. My lord, your lordship will also see the scope of the investigation. SEBI did not say that they are carrying out an investigation to find out whether there has been violation of my articles and bylaws also. That was never a part of SEBI. So even if this is the inspection we are talking about, my lord, to that extent, whether there's been any violation is not covered by this. Now kindly see an inspection of books for the period 2000-2002 was conducted by SEBI during the year 2002. Copy of the report was furnished. The inspection has brought out certain irregularities in your operations. They are enumerated in the annexure. You are hereby advised to rectify the irregularities and warned not to repeat the same in future. You are also hereby warned to be careful in future and ensure strict compliance with the provisions of the acts and whatever it is, and the laws and directives issued by the circular exchange from time to time. Now, my lord, kindly takes one letter, which I will just show your lordship, my lord, which your lordship will find in my affidavit in opposition to GA1.
রিপ্লাইও দেখাতে পারে রিপ্লাইটা ব্যবহার করে পরে রিপ্লাই আসবে ওরা কি বলেছে yes
but only straight away, there are very many, but I will just point out one, my lord. Page 64, my lord.
yes.
My lord, this is from one Vinay Kumar, who happens to be a manager, market regulation department, cyber security cell, SEBI. And kindly sees this is of Thursday, September 6, 2018. This has reference to trailing mail and SEBI letter of 24th April 2002. But it's found that first, but this is that letter, the first letter issued by SEBI to us to carry out with the annexures.
Right.
In this regard, please provide the status of inspection regarding the 2007 books given in annexure 1. And this is long after this SEBI Malad exonerating letter. This clearly, Malad, distinguishes both the inspections as distinct. And also that we were supposed to intimate them. Now, Malad, may I just come back to the list of dates again, Malad?
Yes.
Now, Malad, 16 July 2003, Malad, this is annexure P13, page 54. Malad, I will be dealing with this on two counts, Malad. One, I say, Malad, this is the Cause of action, আবার চলে গেল। এই দেখো তো আবার চলে গেল। পেয়েছো? ধরে রাখো দুটো। মানে this is মানে page 54. I said this is the cause of action in the writ petition. Nothing else.
Page 54 of the writ petition.
Yes, my lord. P13.
Would you come back to the GA? May.
Yes, well, we'll have to.
No, then I'll keep it. That's fine. Page
And most of the documents in the GA, my lord.
right. We'll have to go back and forth.
Yes.
Page 54, yes.
54, my lord. Respondent number 1 instructed the HDFC Bank to stop crediting any interest.
Page 54.
54, my lord. That is us issuing to HDFC.
WPO. This is a WPO. The writ petition itself.
Yes, my lord. 16 July 2003.
Yes. Your Calcutta. Yes, you have
Yes,
written.
I am writing that payment of interest should be stopped.
Oh, achha.
Now, my lord, kindly sees.
This is which year? It's illegible.
2003, my lord.
In my copy, it's illegible. That's why.
But on the top, my lord, it is endorsed.
Year is not visible at all.
Oh, I'm so sorry, my lord.
My copy. Very well. I've written down.
Yes, my lord. So, my lord, kindly sees it is related to various members. Not only them.
Who is the addressee?
My lord, this would be the HDFC Bank, my lord. And
what is written? Your copy is legible. The left, the dotted lines.
no, my lord, it is not. It is not.
You have pleaded somewhere. Must have pleaded somewhere.
Yes, yes, my
Who
lord.
it was written to?
My lord, kindly sees para 25.
This is P. Yes.
Para 25, my lord, kindly comes to para 25. At page 9, my lord.
Respondent bank.
My lord, that is very important, my lord. Respondent bank.
No, that is the HDFC.
I don't know where they got them from.
Respondent bank is not. No, respondent bank is.
Not them. There must be some from some other pleadings that has come through. But whatever it is, one of the respondent bank is the HDFC, my lord.
Very well.
Then kindly sees being agreed by, my lord, kindly sees 26. Para 26. Agreed by this, my lord, they filed 2 writ petitions.
Yes.
My lord, the first writ petition, my lord, next page on page 10, 1829 was relating the termination and surrender of trading membership. Nothing to do with, my lord, this proceeding. And, my lord, kindly sees preferred a title suit before the city civil court. Grant of injunction is a matter of unauthorized purview of the ongoing inspection. So this was the scope of that suit, my lord, which included, my lord, this proceeding.
These writ petitions, what happened to this?
My lord, they were subsequently withdrawn.
Withdrawn?
My lord, that's what they say, my lord, kindly sees 27.
Yes. Pressurized, unduly pressurized to first withdraw all its pending cases.
So, my lord, they have withdrawn. My lord, there is no details of when, why, what pressurized.
Who pressurized?
My lord, that also I don't know. Must be us.
You sat on them.
But I wasn't briefed then. If required, I will, man. If I briefed for that, I will.
No, but this is vague, really vague.
Absolutely vague, my lord. They withdrew.
No, this is because it was being discussed among us. You're Jayanta Chakraborty.
Shengupta.
Every time.
Bodhi, my lord, very difficult.
My fault. Now, we are discussing with, I was discussing with Mr. Shengupta because whether the scope of challenge of this writ petition, and so whether the surrender, he said surrender was not challenged here. Surrender was challenged in a previous writ petition. And they was to withdraw. That
and, my lord, they also don't say, my lord, that they were granted liberty to file afresh.
No. Because of the pressure, they forgot that.
They forgot that. Even if they forget that, my lord, the consequences of CPC will apply, my lord, to a certain extent. And especially, my lord, or with regard to, my lord, also this ongoing inspection. The initiation, the violation of nature, this part, my lord, I say, my lord, would stand covered. Then, my lord, kindly sees.
That was one challenge, termination surrender.
Termination surrender, and the rest, next one is inspection in the title suit.
Yes.
This one got them?
Yes, yes.
Yes. And both were withdrawn.
No, there were 3 writ petitions. The other WP 1360.
Sir, yes, all 3.
All its pending is that's very well.
All. Both the writ petitions as well as the suit. They also do not give a date as to when this was done. They are putting me at a gunpoint saying that it is a delayed proceeding. But I do not know when they have withdrawn. And this writ petition is then filed in 2022. Then 28, kindly sees. 2013, they give a letter annexing all documents for surrender of membership. Respondent number wrote that it shall permit the surrender of separation when the legal cases are settled.
All right.
Then 30.
But in the indirect name, you did not take any other inspection, did nothing.
No,
Absolutely. Why? I mean,
because there was a specific case in that. That is the explanation given to me. But there was no injunction. There was no injunction.
Yes. But then the time bar applicable in an investigation of
initiated. Once it's initiated, then
no question of any time bar in an investigation.
I would have said the thing. Your lordship might have taken me on this. Yes,
you can indicate.
Then most of our cases, we would not have the burden anymore.
Yes.
So, then, I'm just very quickly, 31, they say they've withdrawn. Again, they say this 2013 continuing, since I'm on the writ petition,
they create a new cause of action, resubmitted documents.
Resubmitted documents, but again in 2013.
Yes.
Then, this was basically a case of Order 12, Rule 6. They are saying we gave them an assurance. If they withdraw, we'll give back the money. And they are trying to take a judgment on admission. And then they continue. Why I'm saying this one, just very quickly, since I'm on the writ petition. Kindness is 36, page 14.
Yes.
The petitioner thereafter wrote to a respondent by way of a letter of 2018 stating and taking reference earlier communication, further clarifying the stand of the petitioner. There is no relation direct or indirect with Shamsundar Dalmia, that is a corporate body, separate legal entity. Further say the amount of excess security that was held by the respondent number 1 was unlawful. And not refunding the money is untenable in the eyes of law. So this is the scope, this is the cause of action.
Shamsundar Dalmia.
It is one of the promoters as far as I understand.
Oh.
Huh? Or the petition number 1.
They take the point that we are a juristic entity means obviously he has a connection.
Just
pretty obvious. Yes. If I say I'm a juristic entity, that's why I don't have any connection means I have a connection.
It is just in the above.
No biological connection.
They say it's a former director, so the umbilical cord has been severed.
No, it may be born without a biological.
Anything will do. Then replies were given.
Yes.
Now, para 44. And since I'm on the writ petition, very quickly showing the writ petition. Why I'm saying this?
Yes.
Para 43. First, it is submitted as a proposal of respondent want to withdraw court cases filed against them, and subsequently respondent want to take steps to resolve the deadlock and grant permission for surrender of membership of the petitioner number 1, also refund the security deposit. Relying on such assurance, the petitioner number 1 had withdrawn above both the writ petitions as mentioned para 26. After withdrawal of the above mentioned legal proceedings, respondent number 1 acted in an untrustworthy manner, not befitting the status. Very important, I know, in today's
pressurize them to withdraw that.
In today's world, we do not give too much to the verification or the affirmation part. But I have always been told, by Mr. Mitro Senior, to look into it. And I still do, with the hope that it will be looked into. My lord, kindly cease the affirmation.
It's a submission. Whether it was a pressure or not, we'll decide.
Not only that, that I agreed. That's a question of fact, my lord. That's a question of fact.
I agreed. Where is that?
That's what they say.
No, it was your proposal. It's obviously they agreed. Otherwise, they
Yes, that
relying
if
on
you-
such assurances.
Yes. And that's why I said, well, it's order to Rule 6. Practically. But because I have Mr. Mukherjee on the other side, I took the point, Bharat. But I'm sure he would have taken the point also, so that's why I took the point.
Yes.
And as I say, I've learned so much.
Negative quid pro quo.
And I learned so much from for those 2 years, Bharat. I know what he would have said. So now, Malad, kindly see. So, Malad, on the basis of this, the writ petition is filed. And
So Mukherjee might not have taken that point in this court.
I know, Malad, but I take everything everywhere. And if I'm lucky somewhere.
But you understand what points are not being taken because of the
Yes,
court.
yes. But even for enter your lordship's code, I know.
You understand. I mean,
Or else what I would have told your lordship, they'll take the point of mentality first.
yes. Unless the bench and the bar understood each other, there would not be this. I mean,
but that's why I came to your lordship and take it at the very end. But even for that matter, if I can show on the facts,
yes,
then it might be more convincing for me to show to your lordship that part would never.
definitely.
But taking it at the very front, well, I don't
These are vague. These are vague on the face of it. These allegations are vague.
Vague.
And if doubly they are not found by proper verifications, then the vagueness increases. Definitely.
And when it is a question of fact on which they're suing.
Definitely, which is an important fact. Otherwise, the withdrawal remains without the leave.
Yes, that is the fact. And Malad, kindly come to page 23 now. I'll just show your lordship the press. Why I say, Malad, the division bench might have allowed. Not a problem. But your lordship will kindly see whether this cause of action can be, Malad, looked into on the threshold of the arbitration clause, the contractual nature of it. Just because, Malad, the original writ petition, Malad, was admitted and an order was passed, this cannot slip through.
No.
That is what I wanted to submit, your lordship.
So this is the final hearing, so we can look into it.
Yes, but again, Malad, those were not even part of the first hearing. So your lordship will consider it this is the first stage, last stage to consider. We can see prayer A, withdraw, cancel in addition to withhold excess security. Then seize the wrongful withholding of the excess security. Seize wrongfully holding of the excess security.
All on this quantum.
And does not say that I have been withholding on the basis of that.
No.
It does not. It only says I'm withholding illegally because I've told them if you withdraw, I'll give you the money.
Yes.
Now may I come back to the list of dates and kindly, Malad. Come to me.
The plinth of the allegation is the untrustworthy manner, not befitting your status as a stock exchange, which is itself in jeopardy now. So,
that is, if it's a jurisdictional fact, Malad,
yes.
Then, Malad, I will also point out that stock exchange has not yet been, Malad,
no, he said
de-recognized.
Not de-recognized.
Or not de-recognized. As a matter of fact, what I know is, Malad, I think they're joining or amalgamating with some other stock exchange. So to say that wouldn't be the correct. And Mr. Mukherjee knows better.
So then the maintainability of this writ petition would be jeopardized.
Absolutely. And Mr. Mukherjee knows better than me.
He knows better than all of us.
Volvo.
No,
but
what?
He's fighting for stock exchange.
No, that.
So he knows.
Mr. Sengupta has covered everything.
I have only one book. If your lordship just looks into article, I said, regulation 19 for once, Malad.
Yes.
If your lordship. The power of the board for a regular inspection. I'm so sorry.
Regulation 19.
19, Malad, the right hand, Malad, bottom right hand, Malad. Malad, the next page.
Not much I can find. It's like saying full stop in a lecture. Some people do that by mistake.
Yes.
When I came this side, initially I was on the verge of replying, my lord. I mean, it becomes like a punctuation. Like a punctuation, you get habituated. And when you reply to somebody, it comes to your tongue. And
Malad, only one person I've seen, Malad, who could do it and a flip. That is Mr. Mukherjee.
Do what?
Well, at one point, your lordship would be knowing. Justice Banerjee, Sonjeev Banerjee,
Yes.
said, no, my lords. You can say Janab, you can say Sir, you can say you.
Oh, he shifted immediately.
Immediately, he would enter.
Could not have
court.
made my submissions.
But
And it's also very difficult if somebody's some physical ailment
not
is
only
there.
that,
If you ask him to sit and argue, it's very difficult.
Very difficult. You can't argue.
No, very difficult.
And without the rope also, it's a problem.
Yes, everything associated.
And for Mr. Chatterjee, my lord, I understood that his hair was very important.
Which Mr. Chatterjee?
Mr. Pratap Chatterjee, late Mr. Pratap Chatterjee.
Yes.
No, but I saw him. He told me one day.
Oh,
it's a part of confidence.
Only he could have. I mean,
why not, my lord? That is the greatness of every person who can
absolutely.
at least point it out like that. And Mr. Mukherjee, yes, Mr. Mukherjee, my lord,
but he shifted. Mr. Mukherjee could do that.
My lord, we always say Mr. Mukherjee is a person who would use my lord just after 2 words. We all look at, and we also developed in that fashion. He would enter the court, immediately he would go to sir. Next court he goes, he's back to my lord.
Very difficult. Very difficult.
Tremendous. It was tremendous.
Yes.
And he was the only person because we would go, for once I said sir, and then immediately my lord, and your lordship knows
Justice Banerjee enjoyed that. That I can assure you.
But
he enjoyed that.
Those who have worked with him, well, it knew it better. So, well, I had my shift of working with him.
The difficulty of those people is that they get they have a zone of their own.
Yes, they create their own zone.
They create the zone. If you come within the zone, it's all right. If you're not there,
well, one day if I can
either condescending or caustic.
And I know the classifications, Malad. I can't say that.
No, we know that.
I know the classification.
I was in the zone for quite some time, so I know the classification.
No, Malad. But I've seen your lordship.
No, I have been in his zone both sides. I mean that is one of the privileges I have. I mean, he was a mentor to me. On the
I know.
On the bench. So regulation 19.
19, Malad. If your lordship wants to see regulation 23,
23, I'll also see. Yes. But it refers to another regulation 2008. Any action under that? Anyway,
one of the parent is 19.1.
19.1 is. Oh, this has been quoted there actually in that.
Yes. One of the 3 bullets.
3 bullets. D has been omitted to investigate suo motu into the affairs. This is not an investigation. No, it also says to investigate into the complaints received from investors.
That is not there, Malad, here in this case.
Oh, that is also not there, right? So selectively
it uses only 3.
That which strengthens your point actually.
That is what I wanted
to this. Get it. Yeah.
Now, Malad, the next document is, Malad, page 30.
This is 92 regulation.
92. 92. Sure.
Yes, 92. Yes.
Malad, then the letter is of 23rd December 2003.
Yes.
Further information were sought for by the stock exchange. This is page 30 of the writ petition, Malad.
This you placed probably. Khate pate and all.
Oh, man, yes, this I have already placed.
You have placed?
Oh, no, not this one.
Not this.
Not this one.
That's very good. No,
not this one.
Not this one.
This is post the inspection, the first inspection of 2002.
No, but
by our inspection department at your office at such and such, you are advised to submit the following details. As asked by SEBI letter of 24th April 2002. They said that they were not aware of this letter of 24th April 2002. It transpired for the first time before the single bench of this court when Calcutta Stock Exchange pointed it out. If they are saying that they have received this letter, they have never asked for this letter. If they were not aware, they would say, where is the letter of 24th April? As if it made
what turns on this?
No, they are saying this has been created. Subsequently, we are relying on this. Nothing happened.
This does not make much of a difference,
This is also
does
a
it?
violation
Or
of natural justice.
And violation of natural justice that they were not aware of this letter. How far I don't know. But when you are,
even if they were aware, that does not make much of a difference.
no,
The other letters are there.
if they are not aware, if they are aware, my lord,
What
they
would be-
cannot say that it's a violation of natural justice.
No, natural justice. It would be a violation of natural justice if something turned on this letter. Otherwise, an irrelevant
No,
document
that-
need not be
yes,
given.
sir, that is the
That is
test,
what
right.
like
that is-
material suppression. It has to be material in the first.
My lord, if it was the earlier provisions of natural justice, but now it's a prejudicial test. Then nothing prejudicial has been caused to
Not
them.
even earlier, natural justice, there has to be a violation. Audio alternate partem, something irrelevant need not be.
My lord, the only thing is this was brought here for the first time. I'm just trying to show that no, this is not correct. Even for that matter, sitting in an equitable
No,
jurisdiction.
why
my
do you say it's not correct? It could have been brought for the first time here.
My lord, if they are conceding to this letter,
where are they conceding?
my lord, kindly says this to this letter they gave a reply. I'll show that, my lord.
They have annexed that reply.
To this letter.
Huh?
My lord, sorry, my lord, I'll read. By the letter of 23rd December 2003, we have sought for inspection of further documents on the basis of the letter of SEBI.
Yes.
And they have acted on it.
How do you say acted on
And
it?
I'll show the letter in reply to this letter.
No, they say they did not have this letter, December 23.
My lord, if they were not aware, my lord, they would have called for it.
If they're not aware, what would they call for?
My lord, let us say I am referring to.
No, this was referred to subsequently. That is what I am asking.
It is referred in this letter, my lord. My lord, kindly see the first.
No, what is their allegation? 30th of May letter?
No. Their allegation is, my lord, the 24th April 2002 letter.
That they don't have us.
I'm sorry, my lord.
No, I was confused. Very understood.
That is what I'm submitting. To come and say today, I have received it the first time in this 2022. That is absolutely. My lord, I'm trying to show, my lord, even for an equitable jurisdiction, my lord, your lordship will kindly consider that making such statement, which is absolutely, my lord, if I may say so, my lord, incorrect. I'm not using any further harsher words, but it's incorrect. Kindly see the next page, my lord. And this is the letter of 7th January 2004. Your letter bearing 23rd December, my lord, they are referring to. So they have very well understood what is being sought for on the basis of what it has been sought for. Excellent. Now, my lord, they don't say here that SEBI has already given us a clean sheet. No, they don't. They don't. This 7th January, that is November 2003, my lord. 7th January 2004, they said, yes, we are giving you. Now, my lord, kindly see there are three things. We don't have any off-market deals. In the final order, my lord, specifically it has been found that there were off-market deals. Then, we do not have any Khata Pata account. Fund-based transactions without share transactions have been found in the final order. I'll show that, my lord. But I'm just saying this, my lord. And we do not have borrowed, we have not borrowed any funds to tide over any, but this was not reflected. Final order. Kindly see. Further, we would also like to mention, we have carried out thorough inspection of our books for the period of such and such. Failed to understand rationality behind reseeking the information already been made available to you during the course of the said inspection. Such duplication of work is unwarranted and results in wastage of precious time.
This has been the refrain of Mr. Mukherjee's argument also. That repeatedly you are harassing them.
One of the final order clearly shows how many times they've been given the opportunity to produce the books.
They repeatedly say the same thing. We don't have Khatepate and we don't have off-market deals.
But
So why go on repeating unless you show that these are there? These Khatepate accounts have never seen the light of day.
No, it has been. In the final order, yes.
Discovered. Yes. We'll look into that.
We have given this particular.
And my lord will kindly.
You have given the details of the off-market.
Next, your lordship will find next letter. The letter which they have challenged. Now they are trying to challenge. Not challenged. Not challenged. Technically, my lord. Though your lordship is not that technical, But technically, well, they're not challenged. That is the 4th March 2004. Which Naman said that is under
Give
challenge.
specific instances.
I didn't say something.
Sorry, minute.
You have given specific
Yes, yes.
instances of so many.
Yes. Okay, 174. 170, volume 2. হ্যাঁ ওটাই দেখাবো আমি এতগুলো কাগজের মধ্যে হারিয়ে যাচ্ছি আসলে 172 volume 2 মানে 170
of the
174
J.
4, yes, মানে J volume 2. You won't, your lordship will not find it in the writ petition.
No, I was till now. I was
in the writ petition. This is in the writ petition. Sorry, page 32. But it sees the GA
page.
Well, page 174. Mr. Mukherjee has also shown it from the GA.
174, yes.
Same letter, man.
Uh-huh.
Please refer to an inspection of your books and other records. You are advised to submit your comments on the following violations observed from the books and documents produced by you. You have entered into many off-the-floor and negotiated deals which are not reported in the exchange. This is in violation of the SEBI Circular of 1999 and our exchange notice dated 16 September 1999. Violation
Mr.
of
Mukherjee
notice.
argued that no period has been specified. Item 2, page 175. Or in any of these. No particular period has been reflected. You just say 335. Some instances are given below.
Let us see the first inspection.
Even the general period is not given.
Well, it is pursuant to that. There the period has been given. 2001, 2001. And they have also answered to this.
The letter was dated 2001, 2002.
Oh, the original one.
9th May 2000.
No,
Ninth May.
original, the first inspection.
No, where it was mentioned, this is the period for it.
And I'll just point out. No.
No, it must be there in this letter itself.
Yes, ma'am.
In reply to something. Yes, please refer to. Oh, they refer to the inspection itself.
My lord.
No, as per letter
Yes, ma'am.
dated 23rd of December.
My lord, 9th May 2002.
In this letter, you say, please refer to our inspection, other records on such and such by the such and such team asking for submission as per letter dated 23rd of December 2003. You connect this to 23rd December
Yes.
2003. There you had mentioned the period.
That is also connected to the original of 30th. 9th May 2002. Asking for specific 2001, 2000 documents.
All right. Very well. So this entire thing then should be for that period.
Yes. And Malad kindly appreciates Malad.
No, but in the next page, Sanjay Khemani, these dates,
Malad,
2000
Malad,
and
23rd December
2000 has been covered also.
Malad kindly sees 23rd December specific periods have been given. 1st April 2000 to 31st March 2001. 1st April 2001 to 31st March 2002.
So this is for a period beyond 2000, 2001 or 2001, 2002.
Malad kindly sees page 174.
Yes.
On the top, Malad, your lordship will find settlement number and Malad begin date of settlement. That's of 2001. You also got that, Malad?
Yes.
Just below that, Malad, also, Malad. These transactions of 2001.
Now, item 3, page 175, the last table.
I'm coming there. Malad, I'm on the first page. I'm just showing that first.
Achha. Date of settlement is, what is this?
Of 2001.
0 and.
That is the other American style, I believe. Malad.
What style?
Malad, the Americans, they write it the other way around.
No, 6, 8.
Oh, not that one, my lord. Oh, I'm on the top of, upper one, my lord.
No, upper one American standard we can understand, but what about the lower one? And upper one also,
And it talks
the
about
digits seem to be a bit
6, 8,
fudged.
99,
This is
5th
a better
January
copy.
2001.
No, actually, the writ petition one is the better copy. Let us just note it down. Well, I'll follow from there.
My lord.
Yes, yes.
Then, my lord, 3, your associated firms have fund transactions with Khemani and Singhania Group. Transaction as follows. My lord, the period is given on the left.
Yes, yes, right.
For each.
Sum of 2000 also there, page 35.
Yes, I've asked for 2000 also.
So you said 2001 to?
No, I'm sorry. December to be correct.
What is the page number of the 9th May letter?
Yes, my lord. 9th May. But 1st May I showed 23rd December, page 30 of the writ petition.
Yes, yes.
2000 to 2001.
So there itself, yes, page 30, right?
1st April 2000 to 31st March 2001 and 1st April 2001 to 31st March 2002.
Yes, you given the specific period,
Yes.
this.
My lord, may I just say this, my lord?
While 9th May, while go back to 9th May, in this itself.
Yeah, I've given. But may I also say no? Why I'm saying 9th May, my lord? I have specified that I can ask for any documents for any period.
That is very difficult for them to furnish.
My lord, if I can give them the document, if I can give them the particulars, then they can definitely, my lord.
Yes.
And we have given the particulars. And the specific cases, my lord, we are finding it that there was fund transfer with the Khemanis and the Singhanias.
And you've given the specific
Yes, and this is what was first, my lord, initiated by the SEBI with regard to Ketan Parikh.
Yes, Khemani, Singhania, and Biani. Biani, I'll remember for
Biani.
And Pudar.
And my lord, first is for the Khemani. Next page also Khemani. Then the 177 is Singhanias. Specific, my lord.
No, let us be clear, Mr. Why we are a bit, we recollect on Biani because of the food item. Because we were on camera, later on this will be construed that I had some link with Biani or something like that. Biani is rhyming with biryani, that's why.
Obviously,
let us be clear on this.
Obviously.
It should be in the same footage.
But I don't have.
Nowadays we are very cautious.
Yes.
Up, down, right, left, every side.
And
Vulnerable. High court judges are the most vulnerable now.
I mean, this thing, my lord, kindly consider.
This thing, that thing, right, left, above.
But if I ever get the chance, my lord, where I can meet other than in the court proceedings, but I'll point out to your lordship, my lord, what this is creating.
We all know.
And not only the YouTube, my lord, even, my lord,
not YouTube.
With regard to us.
YouTube, I don't blame. Mr. Rai, actually, I am not averse to this live streaming. I am in favor of live streaming because we are supposed to be open courts. Let it be on the YouTube. People will get mature after a time. They will get bored with these things. Now only the portions where the judges are angry, those are being. They will get bored of this. Let them exhaust this. So no difficulty.
They are
that.
editing them.
Morphing is difficult. Editing, yes, some portions.
Morphing, editing, they are part of editing.
They will also grow tired of this. They'll sure outgrow themselves out of this. Gestation period is required. Within 1 or 2 years, people will get mature. I'm not much bothered with these things. People get these things when they come, they are new, then people are,
I'll point out,
they won't have time later on.
I understand everything.
Courts are doing
I understand everything, Malad. But one thing, Malad, must also consider every profession has its inbuilt natures.
Mindsets also, Mr. Rai.
That is one professional mindset.
Let everyone know whatever is happening in open court. So what's the difficulty in that?
Well, the difficulty is, Malad.
Editing is.
Let us say, Malad, today your lordship, in some matter, Malad, we used to always say we do not know how the judge will be of the mind, Malad, because judge is also a human being. Your lordship might say something to me.
We make some loose talks or something.
Your lordship might say something to me.
Or casually. Or we always put
your lordship, when we do a matter, identifies us with the client.
Yes.
Your client lordship don't see the client. So, my lord, yes, we get the bit.
But notionally, Mr. Rai, if anybody and everybody, any citizen of India can come into the courtroom, why can't he or she look
Well,
at
they don't
us?
wait for the next day. They don't wait for the next moment. They only see that, and that's what is promoted, my lord.
No, if they can see it sitting here, they
Then
can
it
see
is
it online.
promoted,
also.
my lord. That is the problem.
Content creators and all.
That is the problem. My lord, few days back, my lord, I was appearing. The last few days of the government freedom, my lord. When I was appearing, my lord, there was
was edited.
My lord, it was edited, and then it was said that it was someone has won.
Oh,
someone has won the matter. The government has lost, and my lord, pure advertisement. So, my lord, these things are which, my lord, I know, my lord, these are a huge topic, my lord.
Yes.
So, my lord,
let's be with the biryanis and the biryanis.
Yes, my lord.
Yes.
Then, my lord,
So you have given the specifics in this.
specifics, and now comes to 178. My lord, just after these, my lord, boxes, my lord, the above leads to a conclusion that you are responsible for the act of circular activities. You have not maintained a record of time of placement of orders by the client, which is in contravention of SEBI circular. Not maintained margin books, again violation of SEBI circular. You were also asked to submit the details of fund transaction made through journal entries, which you have pleaded in, could not be identified. Also sold such and such amount of equity shares of HFCL to Dow Jones and Companies Private Limited in the C-Star system on 9th March 2001 with an intention to defraud. My lord, kindly see. Here is where what is very important.
Defraud the what? This
The
is
security fund, settlement
guarantee.
settlement.
Sorry.
Oof.
For some reason, I'm sorry. It's a settlement guarantee fund.
Oh,
It's a part of the bylaws of the exchange. And this says you are violating the exchange bylaws.
Need not be so menacing.
It's
very difficult for you to sound menacing. You're too roly-poly for that.
I know my son also doesn't take me seriously.
No, what is sons take one seriously? But
Nowadays they don't.
in our generation.
Nowadays that's
Your generation different.
My God, my father would look at me.
But your sounding menacing does not go with you.
But whatever, man, this I'm
created on the code. Impact created on the code.
This was the other part of it. Not only the SEBI part. This is that part which has allowed.
You have given the specific details.
Yes. Now, Malad, next, Malad, on the last paragraph.
2.11.
Oh, Malad, last paragraph, Mr. Choim.
Yes, yes, Dave.
Suffer
In the circumstances.
Which was executed in the system with a pre-negotiated arrangement. In this process, Dow Jones suffered to the tune of rupees 2.11 crores, which was, now kindly see, I'm grateful to my learned junior, which has ultimately drained the SGF. Well, dear Lordship knows what is the scope of the settlement guarantee fund, I just point out. Well, because that I have done a suit, so I'm aware of it.
No, last occasion you taught me, but I've forgotten.
But I did not reach there. I will show the particular.
No, somebody, Mr. Mukherjee.
Mr. Mukherjee, I will also try and. It's a general fund which is created by the stock exchange.
Yes, that much. Yes.
If money comes in and someone doesn't pay, I mean, very colloquial terms I'm saying, Malad. If the broker does not pay to another broker, it's the guarantee fund which is invoked and money is given.
Recollect now.
And this guarantee.
That's why it's a settlement guarantee fund.
Yes.
Understood.
If settlement is not done by a broker,
Covered by
that is covered.
So there's a drain of that.
Yes.
Yes, remember.
So therefore, my lord, it impinges on the funds of the stock exchange.
That's public interest.
That is the point. Next, my lord.
What? Up to this? What will happen for the next 8 minutes? You'll have to bring some verandas for me to fry.
Disturb.
So you have prepared. You have got up to this, or you don't have the next?
No, I have. I have, Malad. Then Malad kindly comes.
No, this is all you have to argue. What else remains?
No, Malad. Most important is the final order.
Start pressing it then, if you want to. The next 7 minutes now. Something else remains on this.
Only the communications, to the extent they have accepted these inspections, they have given documents pursuant to the inspection.
Refer to the pages in your written notes and
I'll do that.
tell
I'll
me
do
in
that.
open court so that they're aware.
Do that,
So they can take note. Your learned friends can take note.
Do that.
Because in any event, even if I go through, it will have to be referred to. But if it's something is clinching, then you can show. I mean, they've accepted what? Receipt of the letters.
And they replied to all of these. Violation of natural
What is the
second
tenor
law.
of their reply?
The inspection report not given.
Something not given or the other, something or the other not given?
Not given.
They have said that this was the show cause notice, 4th March to the response. They have issued a letter which is appearing at page 1.
How many such communications are there approximately?
6 or 7 of them.
You can start placing those.
Yes, I'm placing, Malad.
This was the
Malad, kindly takes the next
page 179.
page 179.
Hmm.
It's just after the Malad. It's the response now. And the response is this. Malad, kindly sees.
If there is something important in the
Yes, ma'am.
other, because the difficulty, Mr. I am telling you frankly, because local is taking up so much time, the other matter.
Right.
I mean, we don't know when we'll be reaching these matters again. So I want you to finish as quick as possible the oral arguments
And only one.
and come prepared on written notes so that I can put it as to be mentioned. And
I will take one more day. And
we don't know when we can give you that day.
Well,
The difficulty
I will
before Puja vacation also we don't know because local is going on and on.
I will wait, Malad. I cannot finish in the next 5 minutes. It's not possible.
No. 5 minutes.
I will do it on the next day, Malad. I'll also get what I'll do, Malad. The judgments also I'll prepare the compilation. But Malad, I'll one indulgence, Malad. But if your lordship does not take up the matter next Friday.
Next Friday, I
26th.
assure you I will not take up.
I'm very good.
Next to next Friday.
Hmm?
Next to next.
What a Friday? Oh,
Next Friday is
Malad, sorry, 22nd, Malad. 22nd, Malad, if your lordship can.
22nd, I can't assure you. If local fails, then I'll take up.
But kindly, Malad, kindly.
No,
only
and
one
the
day.
same thing will happen to you. Mr. Sengupta will have to manage and what. You are not there in Calcutta.
Okay. That is why Malad, only. And
Let it be
29th,
in the list. Let
let
me
it
not
be in the
disturb
list.
the list. Yes.
Malad kindly allows an adjournment. 29th, I will only, Malad, first half I will.
Second, if I take up by any chance, Mr. Sengupta, remind me that he sought for an adjournment on 15th August. I'll remember. So please, at least one letter, let us kill 4 minutes.
Very, very quickly, Malad. You are, members, Malad, third paragraph. Please also note that we are in no way connected with one RL Poddar mentioned in your above letter. Neither have we transacted for him as alleged. Corporate transaction 24,200 shares of HFCL is incorrect. In fact, we are the net sale position of 25,000 shares of HFCL in CSC settlement. During that period, HFC was in no delivery. The relevant final derivative statement of CSC reveals RL Poddar being the counterparty receiving members of such.
Actually, Mr. Sengupta had a point before you came that if we have to go into so much of detail,
That is what I intend.
that's a fact-finding exercise.
That is what-
Mr.
that is
Mukherjee will have to answer that.
That is why I'm placing this one. Malad, I'll be very candid, Malad.
Yes.
To the extent
Unless they win on the threshold points.
because Malad, these are very technical.
Absolutely.
Very technical. I will also show. That's why I said, Malad.
That's a question of appreciation of evidence then.
Absolutely. And Malad, I will also show that these things were dealt with in the final order.
Yes, that you have to show. So if
I will
these are
show
dealt
that.
with, then we'll think over.
I will show that, Malad. That's why I'm placing this, Malad. Whatever they are saying, I'm just placing it very quickly, Malad. Then Malad just notes it that they have given their Malad.
Under each head, they have given their
response in
stand.
whatever way they could have.
Yes.
But Malad. But Malad, they have not dealt with each of the transactions which we have provided to them or given their comments. It's a in general comment. Holistic. Malad, we gave them the details for specifics. They wanted to be holistic. Malad, that is okay.
With an intention to find holes in the defense.
So, Malad, thereafter, Malad, we again gave them a letter 23rd March.
Yes.
Malad, because we are giving these letters, because Malad, from the responses which they are giving, Malad, it becomes evident that they are withholding.
Why do you say that?
Because, my lord,
They've taken some points. They've
my lord,
given
they have
grounds.
taken points. My lord, kindly, my lord,
Some
appreciate.
grounds that they
Where I am giving them the details, they are saying no, we never had any transactions. These are from the SESTAT. I said these are from the SESTAT system.
Mr. Mukherjee also took a point, probably if I recollect correctly, that whatever was missing, you could have found out from the system itself. That was a point taken by him. I mean, it's not that they are withholding something.
Well, that is
You
what,
can just check up the system and find out. I mean, it's not their withholding or not. It's in the public domain.
yes, well, that is what we have given them. We've given them
So
the
you
details that
could
they
find
have
out in
not
the first place. Why haul them up for
because
suppression?
they have not disclosed the transaction. They were supposed to disclose the transaction. Malad, there are not one only, Malad, if I say, Malad, allegation which are finding against them, there's several. They are not disclosing transactions. They have not paid up as a Malad, broker for which the settlement guarantee fund was invoked. And Malad, there are also Malad Khate Pate account has not been disclosed.
And every time you have to point out the.
I'm pointing out.
Like page 184.
Malad, if I give them details, then also they will say there's violation of natural justice. And if I don't give details, or rather, if I give them details, they are saying that why are you presenting the same
Before
details?
is very important because you have given the particulars of
Yes.
many things. Anyway.
Uto?
Chal. The...
Very grateful to that.
Why very? Because
no.
Art also.
If I could mention, Malaj, item 9 and 10, I'm so sorry I was not there in the morning.
No difficult. We had passed over, but since we'll take up appellate side matters from 2, so on the next date, yes.
No difficult ones. I'm much of it.
Thank you. 2টা এটা আজকে একটা 1 আছে একটা 1টা কোথায় হ্যাঁ না
অনেকটা করে দিচ্ছি
হ্যাঁ দাঁড়াও এই যে সরি এখানে ঠিক আছে
May I have your lordship's leave to mention an original side matter?
Original side, when I take up original side matters.
Lordship.
Should have come in the morning.
Yes, your lordship, I missed my chance. Lordship, I'm just praying for leave to file.
No, we
an-
don't take up. Leave for what?
Leave for filing an application of, for modification of your lordship's order, without the full cost title.
Without?
Without full cost title. This is actually a company matter where the company has gone into
Leave is
liquidation.
granted. Is the officer there? Leave is granted. Yes.
I'm grateful.
Any other mentioning? No. Call on the list.
Lordship, 2 applications are there, so
Both.
I'm grateful.
Leave is
Lordship.
granted. Yes.
One and direction on 18th of July 2025. Lordship has already closed the oral argument. We should further
Written notes, yes.
We are only filing of the written notes of argument. We have
My
exchanged our
written
written
notes is very short, not compared to.
because I have highlights all the irregularities which have been done.
Shorter written notes have a better chance of winning. In my... No, but let this not be construed to be. This is not serious. Thank you.
My lord, I have already served. This may be kept with the record.
Written notes of arguments filed by the parties today be kept on record. Hearing is concluded. The matter is reserved for judgment.
Obliged.
2 p.m. today. Yes. Did. Yes, you're for the petitioner.
Last location, Advocate General
Yes,
Secretary, due to his inconvenience, we are
No difficulty, sir. You are there.
Continue is present, Mr. Chairman, already. When we tendered apologies, already we filed a report, Lordship.
You have, what about the other complaint?
Complaints, but he has not made, we did a complaint, Lordship. Come to the page, next time.
6, 7, 8. Lordship, I also have to say, your lordship, regarding this matter. As the petitioner.
Yes.
Paragraph 6, 7, 8. Paragraph 6, 7, 8 in my pleadings, when I come to the minor, the initial my lordship, the answer A to a petition, page 9. He
has lodged a new complaint.
Yes, he lodged a new complaint. That is another issue, Lordship. But in this,
but that was not the subject matter of
no, Lordship. We have complained your
Order has been passed in respect to that.
The order has been passed when annexure B
Within time.
within time, Lordship.
The other complaint, there were 2 complaints.
One has
been disposed of on the last occasion.
It is last.
This is the second.
Thank you.
So this happened before my previous order. No,
After, Lordship.
Within the extended time,
Within the extended time, we have done this. He not intend to proceed in this matter, Lordship, but we have passed the order. My lord, you see
Yes, what do you want to?
Your lordship, my contention is that the complaint was not in a proper form, as was told to petitioner on 15th when the hearing took place.
That's why withdrawn that and filed a fresh complaint.
Your lordship, yes, your lordship, your lordship. And therefore, a new complaint was lodged, and the petitioner does not wish to proceed with the contempt, and he prays for purging the contempt.
Learned counsel, we hope no pressure was created on you.
No pressure was created.
Are you sure?
Your lordship, it's absolutely sure. I've spoken with the petitioner today in the morning also, your lordship. There was no pressure created.
The petitioner is an advocate also.
Your lordship, petitioner is an advocate of
Paragraph
Malda
9,
Bar Association.
Paragraph 9, we have pleaded in this matter, Lordship.
You personally had a talk with the petitioner.
Yes, your lordship. Today only I had a talk.
An affidavit, the contemner is personally present in court. An affidavit of affidavit of compliance is filed on behalf of the contemner. Learned counsel appearing for the contemner point out that subsequent to the previous order dated July 11, 2025, passed in the contempt application, the petitioner withdrew the second complaint, which remained to be decided, in view of a fresh complaint having been filed. An order was accordingly passed on the said complaint in the light of the request of the petitioner to withdraw the complaint. Next para, the copy of the letter of the petitioner intimating his desire to withdraw the previous contempt in view of having lodged a further complaint, as well as the order passed thereon, are brought on record as annexures to the affidavit in compliance. Upon a perusal of the said affidavit, and upon hearing learned counsel for the petitioner as well as learned counsel for the contemner, comma, this court is satisfied that the act of contempt, comma, if any, has been purged. Full stop. As such, comma, no useful purpose would be served in keeping the matter pending unnecessarily. Full stop. Accordingly, WPCRC 89 of 2025 is discharged. The connected contempt application also being CPN 1675 of 2024 stands disposed of. Consequentially, full stop. Needless to say, comma, further personal appearance of the alleged contemner is dispensed with.
Get full.
Thank you very much.
Your Lordship, the withdrawal was on the ground that it was not in a proper form.
I have repeated thrice, not in proper form.
Because the complaint was not in a proper
But in the letter you have written that since you have filed a new complaint.
The new complaint was filed on that
A
ground
new
that
complaint,
the
not
previous
this
complaint was not in a proper form. It's in the order dated 15th July.
In view of the new complaint, you have stated in view of my new complaint lodged today, I do not intend to proceed with the alleged.
Yes, Lordship. That was because of the reason that the previous
That may
complaint
be
was not-
whatever it
This
is.
is another issue. Get full, Lordship.
Thank you.
Much obliged, Your Lordship.
Yes.
My lord, I am for the alleged contemner.
Why did you commit the contempt in the first place?
Last occasion, already complaint report has been filed and
Complaint
prisoner
with?
has already give a copy.
Let us see. Oh, their allegation was that you had not decided. But on the last occasion, you handed over documents from which I recorded that prima facie it appears that it was communicated. None appears for the petitioners at the time of call, full stop. Next para. By an order dated July 18, 2025, comma, it was recorded by this court that a bunch of documents were handed over in court by the alleged contemner, which indicated prima facie that the decision stroke report of the BL and LRO was duly communicated to the petitioners, comma, contrary to the allegation made in the contempt application. Full stop. The matter was then adjourned on the prayer of the petitioner's advocate to take instruction, to enable him to take instructions in that regard. Full stop. However, comma, at the time of call, none appears for the petitioners. Full stop. In view of our previous order, comma, it is evident that the contempt application is frivolous, comma, since it was communicated before the contempt was filed. Acha. Frivolous kothata deben na. The contempt application has been rendered infructuous in view of the order of this court having been complied with. Accordingly, CPN 573 of 2022 is disposed of as infructuous without an order as to cost. Thank you. Yes, Salda.
I am for the petitioner. Lordship,
The contempt
before starting,
Reply.
Lordship, I am praying 1 week short time. Lordship, petitioner is hospitalized in ESI. Joka Lordship could not affirm the reply.
Very well. On the prayer of the petitioner, the time for filing affidavit in reply is extended for a week from date. Full stop. The matter be listed next on August 22, 2025. Thank you.
I'm grateful, my lord.
You have already filed your opposition on the last one.
Yes, I have received the copy of the.
No, you have filed it.
Yes, yes, yes. এই ফাইল করে দিয়েছো নাকি করিনি?
Yes, yes.
দেখে নাও, দেখে নাও।
হ্যাঁ দিয়ে দিয়েছি।
But I am appearing for the alleged contempt. I have the affidavit.
Opposition and reply, yes. Oh, this is the affidavit in compliance.
Yes.
You are giving a copy right now.
Yes.
Have they complied? Have they actually complied with the order?
No, my lord, not complied.
Affidavits in opposition and reply had been directed by the earlier order. Full stop.
Only my lord.
Today, at the time of call, comma, learned counsel for the alleged contemner files an affidavit of compliance instead, comma, submitting that the order of this court has been complied with. Full stop. Next para. A copy thereof, comma, however, comma, is handed over here and now on the learned advocate for the petitioner. Full stop. In order to enable learned counsel for the petitioner to take instruction, let the matter stand postponed till August 22, 2025, when it will be listed under the same heading. The affidavit in compliance filed today be kept on record.
My lord, Last matter, my lord has been pleased to fix it on 22nd.
Yes.
Instead of that, can it be fixed on next Friday, 29th? 22nd, I have got a personal difficulty.
আগেরটা 22nd যেটা বললাম 29th হবে। This is item number 5. Yours is 5 এ ওটা 29th। এই অনিন্দিতা ওটা রেকর্ড করে রাখবেন। হ্যাঁ।
I'm grateful, man.
Yes. Petitioner, yes.
The order has been complied with.
Yes.
It has been complied substantially. It has been placed Lordship's direction on the height. It was mentioned. I am submitting on instruction that the vertical height has been maintained, but the horizontal line is not placed parallel.
But
the cradle guard.
Cradle is not parallel.
Not parallel, so that it snaps. It will not. The cradle guard will not support it.
Not parallel means it's like this, slanting.
It's away from the main line.
No, it cannot touch the main line.
No, but it is not parallel.
Possibly he is saying that it is a little bit
not
away.
below.
It will
Actually, it should be
it is
below
not
the main line.
Not below.
Not below the.
What about that, Mr. Raj?
Well, I have reported that it has been.
No, it has been.
Well,
It has been placed sufficiently above as per your lordship order.
Possibly that position cannot change because the line has not been touched. The cradle guard height has been increased.
So whatever was there, it has
So
just
it
gone
has
up.
been raised.
Learned counsel for the petitioner submits that the order of this court has been substantially complied with. Full stop. However, it is submitted that the cradle guard is not immediately below the cable. Full stop. Next para, learned counsel for the alleged contemner submits that the cradle guard has been shifted above its prior position as per the directions of this court, and vertical linearity has been maintained. Full stop. Next para. Upon hearing learned counsel for the parties, since it is evident that the order of this court has been complied with, and in case the vertical linearity of the cradle guard would have been changed, it might have given rise to further issues, this court is of the opinion that the contempt application has lost relevance. Full stop. Next para, the contempt, if any at all, stands purged in any event, due to the alleged contemners having already lifted the cradle guard above the premises of the petitioners. Accordingly, CPAN 453 of 2024 is disposed of as infructuous. At last. Probably you also got tired with this matter. So, yes.
My lord, I am appearing for the respondents.
Yes.
I am submitting the supplementary affidavit on behalf of respondent number 2.
Lordship compliance has been made.
Very good. Learned counsel for the alleged contemners files a supplementary affidavit. Full stop. Next para, learned counsel for the petitioner submits on instruction that the order of this court has since been complied with. Full stop. Since the contempt, if any, has been purged, no effective purpose would be served in keeping the matter pending. Accordingly, CPN 1516 of 2024 is disposed of as infructuous. Thank you. The supplementary affidavit filed today be kept on record.
Obliged, my lord.
Give your appearances, both sides.
I am for the petitioner led by Mr. Boydurjo Ghosh.
Yes. What about this?
State response preferred an appeal. Appellate court passed.
Appeal is pending. Any order has been passed?
Appeal allowed.
Appeal has been allowed. Good. Learned counsel for the alleged contemner hands over a copy of a judgment dated August 6, 2025, passed by the division bench in MAT 859 of 2025, which was preferred against the parent order. Full stop. Next para. By the said order, by the said judgment, the appeal was allowed thereby setting aside the order of this court. Full stop. Next para. In such view of the matter, the contempt application loses relevance, and accordingly, CPN 1562 of 2024 is dismissed. No arrest to cost. Thank you. The copy of the order of the division bench handed over in court today be kept on record.
Milord,
yes, Mr. Singh.
Milord, in item 10, Lord, as
Praying for an indulgence, my lord. In the recalling application, what I had filed, not on behalf of insurance company contemner,
Yes.
not my learned friend, not the other side, not has filed their opposition. My lord, my reply is ready. It is not affirmed, my lord. I got the opposition on 5th, my lord. There were 9 oppositions.
We'll give you 1 week's time.
My lord, 1 week's time, my lord. And Mr. Mojumdar, my lord, is appearing on behalf of insurance company, lordship. Abratosh Mojumdar, my lord, the learned senior counsel.
He's appealing for the
insurance company, lordship. Remembers, my lord, it is
Yes.
not an.
You are also for the insurance company.
Lordship. My lord, he's addressing before honorable division bench. My lord, he requested to pray before your lordship, my lord, to make it on 22nd, my lord, if my lord is kind enough.
My lord, I'm not appearing in 11. I'm not appearing in 10. I'm appearing from item number 11, my lord. I have arranged it serially so that it will not be a problem for my lord's court officer to keep it in.
Thank you very much for that, Mr. Raj. So you also do the same thing, but on.
My lord, yes, I'll get it affirmed, my lord.
Fair.
11, 12.
Learned counsel for the insurance company, should he record the name of Mr. Mujumdar?
No, my lord, no.
In 10, I am not there. Mr. Shoni Ojha is there. For the bank.
Learned,
10,
you are appearing only in 10.
10, I am for the petitioner, my lord.
Yes, you are appearing only in 10.
My lord, I'm in from 10 to 20.
10 to 20.
Lordship. For the insurance company.
And you are for? In which matter?
I am from 11 to 20, my lord, for the Punjab National Bank.
Just write the item numbers in your slips.
Lordship.
For the item number 16, only one matter, my lord, one contempt application, 2 writ application. My lord. That is the difficulty. Your lordship previously, my lord, occasion, my lord, your lordship released my one of the client on the basis of submission. But that order was not possibly uploaded in view of the fact that contempt matter is one, but there are 2 writ applications. That is the difficulty.
Which matter? Which matter?
Item number 16, 1994 of 2000, my lord, kindly see. 1994.
You are for the?
I am for the Union Bank of India.
17, 18, 19, 20.
No, only one writ petition is appearing.
Yes, but my lord, the order, last order has not yet been uploaded, my lord.
Not been uploaded in 12.866. Must have been uploaded. Must be in connection with the either with the contempt or the writ.
Yes, my lord, the contempt application is one, but the order of the contempt says that there are 2 writ applications.
Order has been uploaded. None of my orders remain unuploaded.
Order upload.
There is no single order of my court which remains not uploaded.
No,
Till
right,
date.
my lord, possibly, my lord, I was under the impression because the contempt application is 1994. 1994 is the contempt application. Each
1997 is 16.
But my lord, I was handed over a copy 1994 and that contains 2, my lord, the writ applications.
199, I don't know. That's not appearing in.
Today, item number 16.
It has been disposed of last week.
1994 was withdrawn.
Yes,
the petition on the
right,
last.
right.
Yes.
And we recorded that order.
Yes,
that
yes,
has
it
been
was there.
uploaded.
It was there in the order.
My lord, I could
Uploaded.
not create it, but possibly I do not know.
No, please check up. It has been, must have been uploaded. On the prayer of learned, যারা যেটা অ্যাপিয়ার করছেন স্লিপ দিয়ে দেবেন সেটা সেভাবে রেখে দেবেন
এইভাবেই দিয়েছে যেরকম আইটেম নাম্বার সেইভাবেই সাজানো আছে
Learned counsel for the insurance company seeks an extension of the time to file reply. Accordingly, the time for filing affidavits in reply is extended for the insurance company for a period of 1 week from date. Next para. The affidavits in opposition filed by the bank, opposite party bank, respondent bank, contempt. Opposite party bank today be kept on record.
Well, this is my opposition in respect to their recalling application.
Acha, opposition of the opposite party bank is in response to the affidavit
in response to the recalling application by the insurance company.
Acha, in response to the recalling application filed by the insurance company be kept on record. On the prayer of the insurance company, let the matter stand over till August 22, 2025.
Grateful to you.
Thank you.
So far, in respect to the item number 16 is concerned, my lord, the order has been complied with and my lord, they have received the entire payment.
Yes.
I obtained all in the payment from
16 should be disposed of.
16, my lord, Somir Mohapatra.
Only
And yes,
16 is Somir Mohapatra.
Yes,
We'll dispose it of right now then.
Well, 16.1 PNB is also there. That has not been disposed of. Insofar as the other bank is concerned, my lord, that was withdrawn by them.
My lord, 99 lot.
It remains pending regarding PNB.
Yes, your lordship.
So then no further order.
Lordship.
Thank you.
16 তে PNB আছে দাদা।
No, I am not PNB.
তাই জন্য বলছি।
Oh,
Yes, put your lordship.
Next.
I'm deeply obliged.
English শেষ হয়ে যাবে?
11 হবে।
In the previous matter, please ask your juniors to give the appearances, Mr. Singh. With the item numbers. You have given, Acha? দিয়েছে তো? Yes, next. 21, who is appearing? None appears to move the contempt application. Let the matter stand adjourned for the day. Yes, Ms. Patra, what is it? Appearing for the first time?
First time, Lordship.
What is the nature of contempt?
Lordship, on 26th April 23, your Lordship passed the order for removal of unauthorized construction if the construction is illegal.
Yes.
To at pace 13, Lordship. The
Communicate, yes, right. What have they done?
only the notice was issued for inquiry. After inquiry, nothing
Learned counsel for the petitioner.
has been taken.
Learned counsel for the petitioner submits that in violation of the order dated April 26, 2023, passed in WPA 2373 of 2022, whereby the respondent authorities were directed to consider the representation of the petitioner and upon giving an opportunity of hearing to all concerned, comma, to communicate, if prima facie satisfied that there is an illegal encroachment, comma, to initiate necessary action in due course of law on such course. Full stop. Next para, it is alleged that mere lip service has been paid to the said order by issuing a notice and not proceeding any further on the basis of illegal encroachment. Full stop. Since a prima facie case of contempt has been made out, comma, the petitioner shall serve a copy of the application on the alleged contemner, indicating that the matter shall be listed for hearing on August 22, 2025, when an affidavit of service shall be filed by the petitioner.
Yes, Lordship. Lordship, one thing to be added, Lordship. Only issuing notice and after field inquiry, nothing.
And
After field inquiry, joint field inquiry
but
was
Ms. Patru, is it strictly a contempt because we directed them only to initiate? We did not frame any time. This should not entertain this application. If they've done a field inquiry,
serve the
serve and come back. I don't
Yes.
think they this.
Grateful, Lordship.
But I am for the petitioner.
Yes.
I am opposing the application.
Opposing the-
Petitioner in the revisional application.
What is the application for?
Application for clarification and
Phone
modification.
Clarification.
What has happened?
Yes.
May I tell you, Lordship, the fact in brief.
This is a dispose of matter otherwise.
Disposed of.
Acha, yes.
My lord, two suits were filed. One by my learned friend's client, one by my client's.
Yes.
He is the landlord, I am the tenant. He filed a suit that he is owner of one garage and one Darwan's room that should not be disturbed. Possession of that should not be disturbed. I filed a suit.
Who are you?
I am the tenant. I am the tenant running the business there.
So their allegation was you were trying to exceed your tenancy area and disturb.
Yes, their claim was that the one garage and one Darwan's room should not be disturbed. The possession should not be disturbed.
Yes.
My suit was that my tenancy should not be disturbed.
Don't disturb each other. That's
No, but both the suits were heard together. His suit was decreed. My suit was dismissed.
your suit was dismissed. They can disturb you, but you cannot disturb them. Why? Mr.
that is
Chatterjee must have prevailed on the trial. No, why was your suit dismissed? Your tenancy case was disbelieved.
It
was only said that they are the tenant in respect of the go down only.
Yes,
They
go
claim
down.
tenancy in the entire ground floor, which comprises the garage, my lord, in front of
So
the
it
go
would
down.
be a conflicting judgment if injunction was granted.
Yes.
I'm placing. But against that, two appeals were filed. In the appeal, stay application was moved. Stay was not granted. A revisional application was moved before this honorable court. Now, at that point of time, the garage, the gate in front of the garage, padlock was put by my learned friend's client, the landlord.
Yes.
The honorable learned judge of this honorable court held that you should move appropriate application.
Right.
After that, my lord, one application for 151 was moved before the learned appellate court.
No, why appropriate application?
For removing the padlock.
Padlock on your on the garage.
Gate.
Main
That-
gateway, right?
Yes.
Yes.
I'll be placing the photographs. From that, it will be clear. Then what happened?
Yes.
But up to this, there was no specific indication what is the name of the gate or anything. All on a sudden, names were put before the gate. One common passage is there that was termed as main gate, and the gate before the parking space was named as the garage gate.
Names are written, that main gate.
Yes, I'll show.
Okay.
This is really what I should say, absolutely
No,
idea engineered by the plaintiff.
yes.
But
And their advocate.
no, I will not say that.
Yes, yes.
After that, my lord,
Yes.
the court directed that the padlock should be removed. Against that, 2 revisional applications were moved by my learned friend client, and your lordship was pleased to dispose of, considering all this, that yes, it should not be disturbed. Against that, my clients moved the Honorable Supreme Court. And the Honorable Supreme Court observed that at this juncture, we cannot interfere, but if it is violation of the order, you can move the contempt. If order can be interpreted, you can move clarification. So I have come before your lordship with the clarification.
So what is the clarification you want?
Yes, I want the clarification that, my lord, the parking space which is there 2 car parking can be done. If he is enjoying 1 car parking, I am not disturbing his decree. But what he has done, the execution application is pending, decree is in effect executed because he is enjoying his car parking. I am not disturbing that. So for my other car parking, that should not be disturbed and gate should not be closed so that I can run my business. My business is business of paper rolls. I cannot bring the small trucks there and
19 of the order is clear. What else clarification do you require?
Why I am telling lordship will kindly see the photographs, what has been done. What is creating difficulty? Unless your lordship directs, kindly sees page 83. Only the photographs. Page 83, lordship kindly sees.
This was produced on the last occasion also probably.
In the
same
revision,
photographs.
in the revisional court.
In the
as well.
revisional code
Yes.
also, yes. Same photographs.
This is the photograph before marking the gates. The extreme right hand side, the small gate, lordship sees, that is the common entrance. And the gate, the bigger gate, there the 2 car parking can be done.
The clear order was that shall not put an obstruction to the main gate.
Yes.
However,
Why
shall not be constituted as a fetter on the petitioner to put a padlock or lock the gates of the garage and Darwan's room, which are the subject matter
Yes,
of that.
kindly sees. Then next page, kindly sees. Kindly sees next.
Divisional court cannot go into this fact finding. No.
My lord, only
What
difficulty.
clarity? This is not a scope of
since
this. There is no
your
scope of
lordship directed that main gate should not be disturbed. Now, what they
main
have,
gate of the premises, it's qualified.
yes, what they have done, what is being now said as main gate, lordship kindly sees. The other photograph. What is creating difficulty, page 95.
95.
Yes, the other photograph.
The other photograph is at page 84.
No. That is the parking to show that 2 car parking can be done.
Achha.
Kindly see page 95.
95, yes.
The bigger gate, what everyone should construe as main gate, that has been marked as garage gate. And the other gate has been marked as main gate by the plaintiff. Now, today your lordship has directed that main gate should not be obstructed. They will not obstruct. They will not obstruct the main gate. But the main gate is smaller gate. This gate, they have marked as garage gate. And they are completely closing.
Say the garage gate is the main gate and the main gate is, but this is the garage gate.
This was never said as garage gate.
Petitioner, who was the petitioner? They were the petitioner.
They were the petitioner.
So they were.
After the padlock.
I said that this shall not be constituted as a fetter on them to put a padlock or lock the gates of the garage and Darwan's room. So they could put a gate lock on the garage. And your contention was that main gate to the main premises. That is the main gate. That is being locked.
My lord, this is the gate.
They can put a padlock as per my order on the garage and the Darwan's room.
But that is
This is obviously the garage, and this for your previous
my lord.
photograph say
I am what I am trying to impress upon your lordship.
they have marked the garage as a garage.
I mean, it was never said as garage gate so long the proceeding was concerned.
The previous photograph shows it's a garage.
The 151 proceeding after the direction.
There are two garages. Obviously, the right hand side gate is not a garage gate. This is the only gate.
But that is not main gate also. That is not the main gate also. That is the common entrance for the.
Their marking won't make any difference. You can write anything. You write on a horse. You can write cow. It does not become a horse.
Correct, my lord. But the order is there that you cannot touch the cow.
Order is no. Order is not horse cow. Order is that you cannot enter the stable. Order is that you shall not put obstruction to the main gate of the premises itself. You gave an impression that there is a main gate to the premises which is being obstructed, so you cannot go into your portion.
I did not give any impression. They gave an impression this is garage gate.
Anyway, but this is what is no clarification.
Only clarification that so that I can run my business there. I don't want anything
that would
more.
be a further order. No. Business or no business.
On anything more, Miller.
No.
He can use one garage. I will not obstruct. But the other garage, other space.
They can put a lock on the garage and the Darwan's room.
Darwan's room, I am not saying anything.
And garage.
Garage
was given in this order itself.
Garage means they are closing my garage also. The garage other than the decreed garage. He has got decree for one garage. Lordship kindly considers. Here two car can be parked. From the other car parking, I can run my business. But in a circuitous manner, my business is being closed. That is my case. One garage you enjoy, I don't disturb.
The Supreme Court also observed in our view, the order of the High Court is not capable of dual interpretation, as is suggested.
Still, the Supreme Court said that if anything is required, you can go before the Honorable Court and ask for clarification. That is the thing I want to place before.
This is not a case of clarification. Sorry, the order is very clear.
Lordship will kindly consider one
council.
Garage I am not disturbing, but the other space should not be disturbed.
So we shall not create anything new. No. Learned counsel for the applicant in the present application for clarification submits that the order passed by this court on February 28, 2025 in connection with CO number 3718 of 2024 and CO number 3951 of 2024 was challenged before the Honorable Supreme Court, the Honorable Supreme Court, by an order dated May 23, 2025, disposed of the special leave to appeal petitions numbers 14197-14198 of 2025 with the observation that in case the order of this court is being misinterpreted or violated, it is always open to the petitioners to move an appropriate application before the appropriate court or in the contempt jurisdiction. Learned counsel for the applicant now submits by placing reliance on the photographs annexed to the present application, that after the passing of the order of this court, the opposite party herein, that is the revisionist petitioner, has labeled one of the gates as a garage gate and the other as a main gate, whereas the gate so labeled, whereas the latter is, by no means of imagination, a main gate. Next para. Thus, the scope of misinterpretation of the order has arisen, and in the garb of complying with the order, the revisionist petitioner, that is the present opposite party, is trying to disturb the running business of the present applicant.
Not trying to disturb. He has stopped my business, absolutely. He has stopped my business.
He's trying to stop running business. Has stopped the running business of the present applicant. Next para. Upon hearing learned counsel for the such allegations are controverted by learned counsel for the revisionist petitioner opposite party. Next para. From a perusal of the order of the Supreme Court dated May 23, 2025, it is found that the Honorable Supreme Court, comma, in unambiguous terms, comma, observed that in the view of the Honorable Supreme Court, comma, the order of this court is not capable of dual, D-U-A-L, interpretation as was suggested by learned counsel for the petitioners therein, within bracket present applicants, bracket closed, full stop. Over and above the same comma, the Supreme Court observed that in case the order is being misinterpreted, comma, it is open to the petitioners stroke applicants to move an appropriate application before the appropriate court or in the contempt jurisdiction. Full stop. Next para. From paragraph number 9 of the revisional court's order, comma, it is found that this court categorically observed that since the impugned orders only stipulate that the petitioner shall not put an obstruction to the main gate to double inverted, of the premises, comma, the same is not interfered with, comma, with the rider, comma, however, comma, that the impugned orders shall not be construed as a fetter on the petitioner to put a padlock or lock the gates of the garage and Darwan apostrophe S room, which are the subject matter of the suit bearing title suit number 19 of 1997. Full stop. From a bare perusal of the photographs annexed to the instant application, comma, it is evident that the garage itself has been labeled with the nomenclature within double inverted garage, double inverted close, garage gate, double inverted close, full stop. Moreover, comma, there is no dispute as to the Darwan apostrophe S room, full stop. The dispute sought to be raised by the present applicants is in respect of the other gate, comma, which has been captioned as double inverted main gate, double inverted close, by the revisionist petitioner. Full stop. Next para. However, comma, the labeling of particular gates by particular nomenclatures by either of the parties does not change the character of the gate as such. Full stop. Next para. Subsequent actions of the parties cannot be a stimulus for the parties to come up on each such occasion with an application for clarification of the order of the court, full stop, in any event, comma, in consonance with the observation of the Supreme Court that the order of this court is not capable of dual interpretation, comma, I am also of the opinion that in paragraph number 19 of the order dated February 28, 2025, comma, it was clearly enumerated that the revisionist petitioner shall not put an obstruction to the double inverted main gate, double inverted close, of the premises, full stop. Thus, comma, the expression double inverted main gate, double inverted close, is circumscribed and defined by the rider, double inverted, of the premises, double inverted close, comma, thereby indicating the main gate to the premises itself. Full stop. Next para. Hence, comma, the subsequent action of the parties by labeling the gates in a particular fashion need not be an event prompting this court to pass any further clarificatory order, comma, as the order dated February 28, 2025 is sufficiently clear in all respects. Full stop. Thus, comma, I do not find any merit in the present application. Full stop. Accordingly, can 1 of 2025 is dismissed on contest without any order as to costs.
Only one submission of lordship would kindly record that he has got decree in respect of one garage and he is enjoying the entire
extraneous to this.
That will do, my lord.
Why should I record all
Lordship
this?
kindly record, because otherwise, my lord, he is entitled to one garage and he has closed the entire garage.
Maybe take your point before the trial court. Appropriate application does not mean this application. You can take out any application at any point of time before the trial court in the pending suit.
Well, for the other application is in respect of the other
23
and 24.
24. There are two revisional applications, two can.
আচ্ছা তাহলে এটা plural করে দেবেন. Thank you. 25.
I'm for the petitioner, Milord. I'm led by Mr. Jishnu Chaudhary, Milord. He is not here today. I'm just seeking for some time
On the last occasion also similar prayer.
Yes, my lord, he was not here, my lord. If I may
The
request,
occasion before that none appeared for either of the parties. Before
Lord,
the respondents were represented.
Well, I'm for respondent number 1 to
Yes,
4,
Mr.
my
Banerjee, you
lord.
were there.
Well,
Yes.
I'm for 4, respondent number 1 to 4 to 6.
Yes, you were
4
there
to
on
6.
my lords, may I
My lord,
be,
no, lot of time has been taken in this matter. Continuous
Yes,
time. My
may
lord,
I-
you see the orders, continuous time.
So
from
Mr.
one
Banerjee
of-
has taken a cue. He is right, in fact.
I
Regularly
agree.
you are asking for time.
I agree, my lords, my lords. I am led by Mr.
So we'll
Chaudhary.
record in our order, Mr. Banerjee, that this is the last chance we are giving to you.
Very well, my lord. May I be,
Mr. Chakraborty, you are giving a last chance to them.
Well, I am ready always.
Yes, you, both of you are ready. Mr. Banerjee is also ready.
Chaudhary had some difficulties on some few occasions.
Yes, but on every occasion it cannot be
At
repeated.
one occasion, I can remember it was a 3:30 declaration, and both of us did not appear. One occasion, one occasion I can
my
remember.
lords, may I, with your lordship's leave and my learned friends, my lords, if your lordship is pleased to keep it on 29th. The only reason I ask this, my lord, I would never make this prayer. Mr. Chaudhary is not here on the 22nd, which is why, my lord, if
The
29
petitioners seek an adjournment till August 29, 2025. Next para. It is found from the order sheet that on several occasions, either the petitioners were not represented or adjournment was sought. Next para. As a last chance to the petitioners to move the matter, the same is adjourned till August 29, 2025.
I'm grateful, my lord. We shall argue it.
I'm not putting in a default clause.
No, my lord.
But please
It is
ensure that
understood, my lord. Default clause is understood.
Default clause is understood. You are saying it's understood.
No,
That
no.
if you understand,
I
it's
will
difficult.
undertake, my lord.
You have to start then. That
Very
is
well.
the undertaking.
Very well, my lord. I shall.
Thank you.
Grateful.
Give your names, sir, all of you.
26, I am for the petitioner, my lord.
Yes.
The matter, my lord, for appointment in the post of primary teacher, recruitment of 2006.
Who is appearing for the other side?
Other side, madam, Mr. Pinaki Bhattacharya. He is the appearing for the North 24 Pargana District Primary School Council, main answering respondent. May I give further notice?
Give a notice and come back. I'll keep it on 22nd. Next available Friday.
Yes, madam.
None appears for the respondents at the time of call. First up, the learned advocate for the petitioner is requested to serve a notice on his counterpart appearing for the contesting respondents, indicating that the matter shall be listed next on August 22, 2025 under the same heading. First up, it is made clear that in the event, despite notice, the respondents remain unrepresented, the matter may be taken up for disposal ex parte in their absence. First up, the learned advocate for the petitioners shall serve a notice, file a receipt on the next occasion regarding such service.
Obliged, madam.
Thank you.
Grateful.
My